I welcome you all on today's seminar, the topic of which is very, very important, NCLT, a new era to corporate adjudication. We have with us today Mr. Justice A.K. Sekri, Honorable Judge, Supreme Court of India, Mr. Justice M.M. Kumar, Chairman, Company Law Board, who have accepted our request to be here with us on today's seminar. I would like to also welcome Central Council members, Mr. Rajiv Bajaj, Mr. Satwinder Singh, our past Central Council member, Mr. P.K. Mittal, Mr. G.P. Madan, Mr. Harish Vaid. I would request our chief guest and guest of honor, Mr. Justice A.K. Sekri and Mr. M.M. Kumar, to please come on the dais. Mr. Dhananjay Shukla, Secretary NIRC, to please come on the dais. Mr. Rajiv Bajaj, Central Council member. Mr. N.P.S. Chawla, Chairman NIRC. I would request Mr. P.K. Mittal to please present a bouquet to Mr. A.K. Sekri. I would request Mr. Harish Vaid to please present a green plant to Mr. Justice M.M. Kumar. I would like to inform our members and quite young members who are present here that Mr. Justice A.K. Sekri, he did his BCom honors from Shri Ram College, Delhi University, and then he did his LLB from Law Faculty in University of Delhi. He was awarded the gold medal for attaining first position in LLB in Delhi University. He was the president of Campus Law Center, Delhi University. He was appointed as Judge of High Court of Delhi with effect from 7th July 1999. He attended and chaired various national and international seminars and workshops and presented a number of papers therein. Many articles are published in various magazines. As a judge, he has dealt with all kinds of jurisdictions and given many landmark judgments. Presently, Mr. Justice A.K. Sekri is the Honorable Judge of Supreme Court of India. Mr. M.M. Kumar, he has been appointed as Chairman CLB. He took over charge as Company Law Board Chairman on 5th June 2015. He belongs to a very illustrious family of Punjab. He has excellent academic and professional background. Chief Justice Shri Kumar holds degree of LLB from Punjab University and LLM from England. He was enrolled as an advocate in 1977. Justice Shri M.M. Kumar was elevated as a judge of Punjab and Haryana High Court at Chandigarh on 2nd July 2001 and later appointed as Chief Justice of J&K High Court in 2012. He superannuated in 2015 and he's a very well known for his independent approach and impeccable integrity. He has authored a book titled Control of Illusion Clauses in England and India, which is published by Ravensford, London. Please give a big round of applause for our chief guest and guest of honor. I would now request Mr. N.P.S. Chawla, Chairman NIRC, to give his welcome address.
Honorable Mr. Justice A.K. Sekri, Chief Guest for today. Honorable Mr. Justice M.M. Kumar, Guest of Honor for today's program. Mr. Rajiv Bajaj, Mr. Satwinder Singh, Mr. Ranjit Pandey, Central Council members, Mr. Dhananjay Shukla, Secretary NARC, Mr. Manish Agarwal, Mr. Harish Vaid, Mr. SP Narang, past President Mr. Krishnan, Mr. Virinder Ganda, past President, Mr. PK Mittal, past Council Member, Mr. Deepak Kukreja, past Chairman, Mr. GP Madan, past Chairman, Mr. Rajiv Bhamri, Council Member, Regional Council Member, Mr. Pradeep Devna, Treasurer at NARC, Senior Members, friends, good morning. Thank you for responding back. NCLT. We all have been hearing NCLT from many years, at least from the time when Justice Iradi recommended formation of NCLT. And since then, NCLT has been offered to us in many ways, in the sense, in many times we have heard about NCLT. May it be 2002 amendment, which never became reality. And after that, it was challenged, Madras Bar Association, it went to Apex Court, 2010 judgment, which gave us the ray of hope, yes, NCLT has been declared constitutional, so it will be formed soon. So as we were expecting, some amendments were made, 2013 Act came, 2013 Act partially and not fully adopted the recommendations of the 2010 judgment of Honorable Supreme Court. And then again it was challenged. 2013 again it was challenged by filing by way of a writ petition before Supreme Court. And then came NTT judgment. So we all were wondering whether we will really see NCLT or not. But let me share that on 14th of May 2015, which is a historical date and a landmark date at least for all of us, because we being company secretaries would be given a level playing field once NCLT really becomes a reality. And once it is constituted, we all would be, we all would be getting a level playing field with all other professionals. As on date, we can't appear in High Court. As on date, very few of our members appear before BIFR, AIFR. But once it is constituted, we all really will get a new area of practice. And keeping the same in mind, we thought of organizing this seminar. And 14th May 2015, why I am calling it as a historical date for all of us, is a date when Honorable Mr. Justice A.K. Sikri pronounced the judgment, which is a beautifully written judgment. I have read it at least 3 or 4 times. The way Honorable Justice Sikri has clarified the doubts which legal luminaries had of whether NCLT really competes with NTT and how it is different. Beautifully captured, Your Lordship. The way your judgment has clarified the doubts and the way my Lordship has given the mandate for formation of NCLT at the earliest, I feel we must put our hands together in big manner, and in fact would request you all to give a standing ovation for Honorable Mr. Justice A.K. Sikri for passing such a judgment. Thank you, Lordship, for giving us an opportunity, because by your judgment, Your Lordship, we all would really see NCLT very soon, maybe in 6 months or so. This is what we got to know, maybe in 6 months, 8 months. The work is already on. Committee has already been formed by Ministry. Draft rules are available. Few more finer things are going on. And I feel honored and privileged after passing of this judgment by Your Lordship. This is the first program on NCLT which my Lord is attending as the chief guest. So I feel honored and privileged, being the chairman, to welcome Your Lordship for today's program. I also welcome Honorable Mr. Justice M.M. Kumar, who has recently joined chairman as a chairman Company Law Board. I have had occasion of requesting him to come to this program as guest of honor, and he very kindly acceded to our request. In fact, he shared with us of the role which company secretaries can play, and I in the capacity of chairman, shared with my Lord that a lot of members presently are appearing before Company Law Board, and that is why we at NIRC thought that we need to encourage our members, young members particularly, to take up this practice area, which is extraordinary. I mean, once NCLT is constituted, our young members would be appearing before NCLT as if they are appearing before High Court presently. And Honorable Justice M.M. Kumar was earlier judge in Chandigarh High Court, which is City Beautiful. And from City Beautiful, my lord was elevated to be the Chief Justice of a paradise of country, Honorable Jammu and Kashmir High Court. And from that paradise, my lord has come to Dilwalon ki Delhi, and I am sure, my lord, we all Dilwalon ki Delhi will cooperate, will give you full assistance and cooperation in administration of justice. And my one request, my lord, if you allow me to permit to mention here, that our members are appearing before company law board very often. But somehow I have not seen our members becoming a member of the bar of the CLB association. So my lord may maybe pass an order or may direct, may allow all our members, particularly the young practicing members, to be a part of the bar association of CLB, and maybe in the NCLT regime also, because NCLT I've heard there are 2 bar associations. So that will encourage. My lord is nodding the head, so I believe my lord will agree to our request. Yes, my lord, as a big round of applause for my lord for acceding to our request for allowing our members to be a member of the NCLT Bar Association. Thank you, my lord, for immediately acceding. That's the beauty of your lordships. That's the beauty, that they don't take time. When a justified request is made, my lord will accede to it. Grateful, my lord. We from institute, my lord, can surely commit to my lordships that we will be fully cooperating for administration of justice in all manner possible. Thank you for acceding to our request. We welcome you to our today's program. Thank you.
Thank you, Mr. NPS Chawla, Chairman NIRC, for a very nice welcome address. I would now request Mr. Satwinder Singh, Council Member ICSI, to please introduce the theme.
My Lordship, Honorable Justice A.K. Sikri, Judge Supreme Court of India, Honorable Justice M.M. Kumar, Chairman, Company Law Board, and former Chief Justice Jammu and Kashmir High Court, other dignitaries on the dais, off the dais, ladies and gentlemen, a very good morning to all of you. I think I've been asked to talk about little bit about the theme, but before this, if I particularly see, if somebody asks me that what is the backbone of the Companies Act, then probably my answer is only one: NCLT. And today I feel privileged, I feel humbled that on our request, which Lordship always blessed me, that as and when we approach, and who, as NPS said, that who finally paved the way for the constitution of NCLT and delivered the historic judgment, and particularly Justice Kumar, who I believe that he will continue as, he will be the chairman of NCLT and maybe appellate tribunal, given his vast experience. Both of them who, despite their busy schedule, they have come here to bless us, to guide us, how to, you see, prepare ourselves for the big opportunity which has come to the profession of the company secretaries. And I acknowledge and I welcome both of them. Friends, before I take up a little bit on the theme, let me tell you that particularly when I talk about Justice Sikri, you see, in any professional career, somebody idolizes someone else. And for me is Justice Sikri, a person who is from Shri Ram College, who was president of the Students' Union. I think it is not in his biodata, but I know that. And when he was the Delhi College of Law, and then an admired teacher when he used to take the teaching there. When came to and elevated in the practice, when elevated as a senior advocate, and he was one of the very sought after senior advocate, by the full bench invited him to come and adorn the bench of the Delhi High Court, and there was no disappointment. Rose to the level of Chief Justice, Acting Chief Justice Delhi High Court, Chief Justice Punjab and Haryana High Court, and elevated to the Supreme Court. And yesterday I was told by someone, maybe I am tempting to tell you for this thing, maybe that some internal assessment which when they were saying that Justice Sikri is rated as the most efficient judge in the Supreme Court, and I'll again tell you for this thing. I think when talk about Justice Kumar, being from City Beautiful, as NPS mentioned, went to Jammu and Kashmir High Court, and the tag it was given, the marvelous judgments. Even I was telling sir, I was told that if there are full bench judgments, when he was the judge in Punjab and Haryana High Court, out of 22 judgments, about 16 were written by Mr. Kumar. Such analytical skills, the grasping, how to take it up. And this praise came from the other colleagues of Mr. Kumar also, and from the bar. And this is how we are fortunate that, okay, he has been selected here as a chairman, company law board, and I feel that, okay, when NCLT will come, he will occupy the apex position there. Sir, as NPS mentioned that the company secretaries, the Companies Act is core to their heart. They are the expert in that. So in order to grab this opportunity, in order to see that how to appear and other things, so we thought that, okay, to structure the program in a manner that most of the cases where there are operations and mismanagement, what exactly are the concepts evolving operation and mismanagement, we should discuss it, deliberate it, because these are the things, maybe as a quasi partnership, or whether the maintainability is there and other things. So we thought that, okay, we should call the experts who can deal with this. And then when there is a practice and procedure, because the code craft is also equally important to be adhered to. In the morning when I escorted, Justice Kumar was saying that sometime at the tribunal level, which is something different than in the high courts, that there is a lot of shouting, this thing. So he want to discipline, he want to make everything. And then he said that, okay, if the company secretaries or other persons are, you see, appearing, he can understand. The lawyers can play with the words, but I can understand. I will promote the company secretaries to come and appear. Please give a big round of applause, Mr. Justice. As regard the one subject, because SICA is getting merged with the Companies Act. NPS has already talked about the RADI committee and the 2002 Companies Amendment, which could not be made effective. Now we are seeing the concept of SICA. But actually, sometimes we feel that, okay, what is the difference between the insolvency and the bankruptcy? Rather, I feel that, okay, the insolvency starts as and when you are unable to pay the debts, which one of the conditions for that winding up for this thing is, if you are not able to. So rather than creating the net worth, it is the liquidity position which makes very, very important for this. And I know, and I specifically requested Justice Sikri because he was deeply involved into the insolvency laws. I know that the kind of work Justice Sikri has done. And when I approached Justice Sikri, I said that, okay, sir, guide us how to go about those insolvency laws. And sir, we would love to hear from you the nuances of those insolvency, how to do, and what are the international practices. And particularly when we talk about the insolvency, all those things, the economics always prevail. So how the jurisprudence over a period is being involved, we would be really benefited out of that wisdom for this. This is how we have structured it up to lunch, because certain programs have to be held. So for security reasons, we had to restrict our program for this up to 2. Thereafter, that program has to be taken it up. So this is what all we have considered for the today's deliberation, and I'm sure that the today's deliberation will take a long way for our updation of the new act, particularly relating to NCLT. Thank you so much.
Thank you, Satyendraji. I would, before I call Mr. Rajiv Bajaj to speak a few words, I would like to welcome our Central Council member, Mr. Ranjit Pandey, and Mr. Saurabh Kalia, member NIRC. I would also like to welcome all the chapters who have joined this seminar through webcast. There are almost 30 chapters who are right now on the webcast, and they've joined the seminar. Now I request Mr. Rajiv Bajaj to speak a few words.
Good morning. Honorable Justice A.K. Sikri, Judge of Supreme Court of India, Honorable Justice M.M. Kumar, Chairman Company Law Board, Chairman NPS Chabla, my colleagues on the Council, Mr. Satwinder Singh, Mr. Ranjit Pandey, senior members of the profession, past presidents, past Council members, friends. I think it's a great honor for us that we have amongst us Justice A.K. Sikri and Justice M.M. Kumar. Sir, I would like to share with you that we as a profession has come a long way. We are relatively young profession as compared to the other professional bodies in India, but we already have 40,000 plus members and a strong tribe of 4 lakh plus students who are rearing to become professionals, and we are growing leaps and bounds. And recently the Companies Act has already given us a lot of recognition as a KMP, as an expert in corporate laws and other laws as well. And I'm sure our members will contribute a lot in the NCLT as well. And I think we have an edge because we know both sides of the story. Because if a corporate lawyer, hardcore corporate lawyer, is a company secretary also, that gives a very big edge because you know both sides and you can handle the situation very well. And recently in the new Companies Act, sir, we have been given the responsibility of setting secretarial standards also. And I'm sure with the secretarial standards coming in, some ease will be there in taking decisions when it comes to litigation, and surely it will be a good contribution from our institute, and we will be looking forward to your guidance and also your support. And thank you very much for acceding to our request to add our members into the bar, and surely we will do our best to whatever way we can support in the efficient functioning of NCLT, and of course make sure that the corporate laws are followed, and the compliance is something which we breathe, we walk, we talk. Thank you so much.
Thank you, Mr. Bajaj. I would now request our guest of honor, Honorable Mr. Justice M.M. Kumar, to address the audience.
Honorable Mr. Justice A.K. Sikri, Judge Supreme Court of India, Mr. Chawla, Mr. Satwinder Singh, and other dignitaries on the dais and off the dais. Friends, the institution of company secretaries is very vital to the corporate world, and it has been rightly said that it has got its proper recognition in the new Company Act. And how it can be further and implemented properly, the time will tell. Your inputs from time to time would keep guiding all the persons who are at the helm of affairs to achieve the object with which the provisions have been made in the Companies Act. This morning I was thinking that all of us have assembled here to listen to a great jurist, Justice Sikri, who have delivered this landmark judgment paving the way for setting up of NCLT. So I thought that I will say a few words, and then, since I am also very eager to hear His Lordship, and I will sit down. I will share few random thought with you. The topic today is a new era to corporate jurisdiction, NCLT, a new era of corporate jurisdiction. Friends, my little experience hearing cases in company law board tells me that most of the cases are under 397, 398, 402, mismanagement and oppression. And lawyers after lawyers would keep on complaining of various acts of directors who are at the helm of affairs of reducing the share capital of one group so that they are reduced to less than 10% and may not have any say in the affairs of the company. But the new Act has brought in many new features. Insofar as the constitution of the tribunal is concerned, now we will have not only judicial members, we will be having technical members, and their inputs, I believe, would enhance the quality of justice, and it will come closer to the ground realities. For example, the chartered accountants, bureaucrats, they are likely to be inducted in dispensation of justice by the NCLT, and soon it is going to be a reality. But there were the past experiences, like we had Central Administrative Tribunal. When Central Administrative Tribunals were constituted, we have members in the Central Administrative Tribunal who came from administrative services. The approach of those officers were distinctly different than the judicial members. The question arose whether they can yell well with the judicial member, because the concept of justice ingrained in the mind of a judicial member is markedly different than the one which is carried by others. Then for some time we toyed with the idea of briefing, debriefing, and some sort of training at the National Judicial Academy. I do not know at this juncture whether the technical members or non-judicial members would require some sort of debriefing, some sort of training at a academy like National Judicial Academy or Delhi High Court Judicial Academy, so on and so forth. I am lacking in experience to say any such thing at this juncture. The other thing, some random remarks I will make with regard to the litigation which is likely to come. You have concept of independent directors now. You have concept of one-person company. Now these corporate social responsibility, then the director performance evaluation, class action suits in the new act. Whether arguing a case under 397, the appointment of an independent director would become the subject matter of attack, to argue that it is an act of mismanagement and oppression. Whether the lack of corporate social responsibility by not taking care of every stakeholder in the company would become a part of 397, 398, or it will be challengeable independently, then performance evaluation of the directors. So these are going to be the new facet of litigation before the tribunal. Insofar as one-person company is concerned, for example, another random remark I would make. One-person company would be a company having 50 lakhs capital, share capital. At the time when it is floated, say with 40 lakhs, next year this company is likely to grow to 60 lakhs, 70 lakhs, it will cross the limit of 50 lakhs. it will become multi-personal company. It cannot remain one-person company. I do not know whether 50 lakh limit is the proper limit. To my mind, it appears that it is on the lower side. One benefit of one-person company would be, in the family companies it is seen, after about 5-10 years, the disputes start in siblings. One group get together under one umbrella, the other group get together under other umbrella, and they try to capture each other's share capital. As a consequence, litigation follows. A well-run company becomes a litigative company, reducing its worth in the market. So these issues, I am sure, you would debate in the technical sessions. Then a very good provision has been added in the new Company Act, corporate social responsibility, ethical principles, how they can be implemented, commercial decency, how can be brought up in the operation of the company, how legitimate expectations of all stakeholders can be met. This has to be put in place in all the companies after the chapters are implemented. The benefit would be a consumer buying the product of the company would readily start buying if he knows that this company is run on ethical principles. An investor would like to invest if he knows that this company follows commercial decency, its products are easily marketable, purchasable by the general public, it will be a profitable company. The investor will feel safe to invest. So if you meet the legitimate expectation of all the stakeholders which are sought to be achieved by making provision for corporate social responsibility, care of all the stakeholders have to be taken. Checks and balances have been created by the new Act. Directors' performance evaluation have also been put in place. Therefore, these few random remarks I have made just to highlight the area where the discussion is required, the nature of litigation which is likely to follow. The Institute of Company Secretaries, I think, is rendering UMN services by bringing out the small handbooks which I was delivered the other day. For example, this handbook on independent directors, then this handbook on corporate social responsibility, and number of others. They, in a capsule form, have spread the information which is very necessary for day-to-day practices. With these few words, I thank the institution for inviting me to this wonderful session this morning, and I look forward to further interaction in the days to come. Thank you very much.
Thanks a lot, sir. I would now request Honorable Mr. Justice A.K. Sekhri to give his address.
Thank you, Mr. Agarwal. And just in a totally different way than Mr. Chawla greeted you, good morning to you all. My dear friend, colleague and brother, Justice M.M. Kumar, about whom it is rightly said that he is a workaholic and in the year 2012, when I went there as Chief Justice, I found that out of 16 full bench judgments written in that year, 12 were penned by Justice Kumar. And you have a good person in him as chairman of CLB. And as I think Mr. Satwinder Singh or Mr. Chawla said about NCLT, so I wish good luck for that NCLT or whatever. Mr. Chawla, Chairman, Mr. Satwinder Singh, Mr. Bajaj, Mr. Shukla, Mr. Agarwal, other very senior members of your institute who are sitting here. Ladies and gentlemen, young aspirants, company secretaries who see a great future in this profession now because of, and that is the theme of this today's seminar as well, new era to corporate adjudication. Of course, participation of the company secretaries is going to be there, and I really like the theme, and I think it is going to be new era to the corporate adjudication. Why I say so? Of course, it is said by the organizers. They have chosen this as a topic. But as a judge, once I am agreeing with it, I have to give my reasons in support of my judgment. Let me start with it, this few facts and figures about the adjudication of commercial matters in India. World Bank about 2 years ago had made a comparative study of the legal regimes in about, I think, 187 countries, and India ranked at almost the bottom, 179th rank was of India. Main reason was lack of proper laws, commercial laws, company laws and business laws, etc. And the slow process, because of which it is a time, much time is taken in deciding those disputes. Because one has to keep in mind that with globalization, when so much of FDI is coming in this country, it is still coming, and people from other countries, when they invest, either by giving loan or in the form of collaborations in business ventures, etc. So they would like to feel secured about their investment, and they will also like some return on the investment which has been made, because this is the, fundamental. And when we talk within India, anybody, as Justice Kumar was saying, that with the good corporate governance, not only consumers would buy the goods, but even the people will like to purchase the shares of that company. So that is an investment, and whenever, because the expectation is, yes, I'll get some returns from this investment. And this is the legitimate returns of foreign investors as well. So in a case like this, whenever disputes arise, it may be a pure commercial dispute where the relationship is still maintained, but then some disputes arise and we have arbitration clauses, it goes to arbitration. Or the topic which we are discussing, when the company goes bust, it becomes sick. They would like, the creditors would like that they are able to retrieve their investments as early as possible and as much as possible. So therefore, if we fail on these fronts in providing speedier justice or in providing proper forum or fora for deciding such cases. This is the result, or this was the result which World Bank said. Of course, there is another recent study which is undertaken by Doing Business Report. It's a, doing business, that if you have to do business in a particular country, then they have come out with the report how far it would be good to do business. And if we compare the ranking which was given by the World Bank and the ranking now, there is a slight improvement. Out of 189 countries which was studied by Doing Business Report, India ranks 137. So it has come inches above, from 179 to 137, but still miles to go. Because if on the one hand we boast that ours is an economy and that is what we project to the world at large, that is what our Prime Minister is trying to do whenever he travels abroad, that come to India, invest here, make in India, and now Skill India program which has also started. And that is the impression which is given to the world at large. Our ranking, if not at number 1 or 2, at least it should be within first 10. And the motive should be to achieve that. In that context, the question comes of new era to corporate adjudication. Why it is called new era? Let us first, although you are familiar with all this, but let me say from my experience as an advocate doing commercial matters, company matters, then as a judge, sitting on as a company judge in Delhi High Court, then as a in the writs, hearing the writ petitions against the orders passed by BIFER, IFER, and then matters coming to the High Court and to some extent in the Supreme Court as well. I'll trace that history before making that point. We had Companies Act 1956, and insofar as the law relating to companies is concerned, it was primarily governed by this act. And apart from all provisions relating to Companies Act, when we talk of operation and mismanagement, we talk of, from the inception of the companies, I would say, till the dissolution of the companies, and in between these operation, mismanagement and working of the companies, directors, removals, appointments, etc., everything, all provisions are contained in this act. Over a period of time, it was found that some of the powers which are exercised by the High Court, yes, everybody knows here that under the Companies Act, it is the original jurisdiction is given to the High Court. So it is therefore High Court judge who would be manning a company bench, who will be presiding over a company bench and doing these matters. But somehow, for certain reasons, not necessary here to state in detail, it was perceived, or it was thought proper, that some of the powers of the company court in the High Court should be given to the Company Law Board, and the powers which have been narrated. To some extent, I think it was justified as well, that I am saying so from my experience as a company judge, because I think sometime in 88 or 89, Company Law Board was established, 91. And but the cases which were there prior to 91, they remained in the High Court. And when I sat as company judge, maybe it was 2004 or 5, those cases were still there. So cases even prior to 91, which were there, many of those cases. I'm not taking credit for that. Yes, it was my duty, but I can say with pride that at least when I found this, I thought that these cases, this is a blot on our efficiency. So within few months, all those old cases I finished. That's a different game, but at a different point. But what I am trying to say is that part of the powers which were given to the High Court were given to the Company Law Board. But insofar as insolvency is concerned, because I find that in the technical sessions, your session is mainly on convergence of SICA. And of course, second section is on practice and procedure in tribunal. So the main theme is on convergence. And it was found that so winding up powers is with the High Court only. Whenever, whether company goes sick or it is bankrupt, a petition is filed for winding up of a company, it was the company which, company court, that is the High Court, which will deal with this. And in the process, yes, of reconstruction and rehabilitation, which may be under Section 491 onward under the Companies Act. So those powers were with the High Court to see, before passing the winding up order or giving a death sentence to a company, that whether this company can be revived or not. But it was found particularly in respect of industrial companies that High Court, with these powers which are given, Section 491 onward, that may not be sufficient. And rehabilitations of the sick companies is important. Not that merely a company becomes sick, it has to be necessarily wound up. First attempt has to be to revive that company, to ensure turnaround. If that is not possible, then winding up. So with this objective in mind, SICA was enacted. And of course, a different body which is created by BIFER and IFER under the SICA. Going little further before I come to SICA, of course that may not be very relevant otherwise for the topic, but it becomes relevant to the issue which I am going to highlight, is that we found that there were, as far as banking industry in this country is concerned, that it was becoming difficult for them to recover their dues by filing ordinary civil suits. So DRT and that long act which came into that this tribunal, the civil courts should not entertain these suits by the banks and financial institutions, and it was given to DRT. The relevance is, I will tell, when in the context of sick companies and turnarounds, because it is mainly the banks or the financial institutions which are the main creditors, and how they can support an attempt for revival, and at the same time they can be responsible to kill that attempt, which I saw as a company judge or while dealing with the cases of BIFER and IFER. So DRT comes. Of course, its virus was challenged as in the case of this NCLT, but that was High Court of Delhi declared the act to be unconstitutional, but this judgment was set aside by the Supreme Court, which upheld the validity of this act. Then a problem of, again in the same, to complete the sequence, in the same direction of the banks, etc., when found that so much of NPAs, non-productive assets of various companies. So how to, even DRT is not in a position to, that going to the court process or judicial process, I would say, would take time, and therefore some powers should be given to the financial institutions themselves. So it resulted in SARFAESI. This is the regime, and DRT and SARFAESI I have said just because of the reason, as I told you, that they play an important and vital role insofar as rehabilitation of the companies is concerned. But then coming back to the three main acts or three main bodies dealing with different facets of the company law. We have High Court, which is given some powers under the Companies Act. We have Company Law Board, and we have SICA. Now, a particular case may be of mismanagement and operation, but at the same time, if that continues, or there is a fight, particularly when these are family concerns or private limited companies, it may not happen in big public companies, but there and where the stakes of both the sides are almost equal, then such disputes, which are in the nature of quasi-partnership disputes, if they go to the court and here in Company Law Board, it would definitely affect the functioning of the company when such a dispute is there, and may bring the company to the brink of disaster. That is, it may face winding up petitions. If the company goes sick and this motion is made to the BIFER, BIFER naturally under the Act, role is to see whether there can be turnaround of such a company or not. But at the same time, it can see only this much. If it can be revived, operating agency would be, if it is admitted, reference is admitted, or the request is admitted, then operating agency would be designated, which will prepare the scheme, which may be normally a main creditor or the combination of few creditors, the consortium. They will present the scheme. BIFER may ultimately accept or reject. And but if the BIFER comes to the conclusion that it is not possible to revive the company, BIFER doesn't have power to wind up that company. So it has to send the reference to the High Court, because winding up power rests with the High Court. What happens? When it comes to the High Court and the notice is sent to the company again, here again, as I said, 491 onward, those provisions are there. Second inning starts in the High Court. That company still says that, look, we are in a position to revive, and it will try to project a scheme of reconstruction. That is going on at one hand in the High Court. But BIFER under SICA, the proceedings are still continuing because BIFER's order is challenged, which is before IFER. And even IFER affirms, because many times we have seen IFER may affirm, it may reject, it may send it back to the BIFER again, or even if it is affirmed, that is not the end. It goes to the High Court. Then it goes to the Supreme Court also. Because as I say, in our country, not only we are litigious, but we are not happy with the outcome at one stage. Every case has to be tested till the end. And I remember in the beginning when I was in the profession, I had coined the word. In our courts or in our judicial system, case goes from SC to SC, small cause to Supreme Court. Even if it originates from small cause court and there are 5 or 7 ladders of appeal, it will definitely go up to the Supreme Court. So therefore, on the one hand, BIFER proceedings are continuing, and it is possible that in those BIFER proceedings, stay is granted. So when the reference is there before the High Court for winding up the company, either of its own, it is giving a chance to the company for revival, or because of the stay orders, it is not able to move further. With the result, even these winding up proceedings would take a long time. Now, take a situation that yes, winding up is ordered, either in respect of a company where the winding up was directly filed in the High Court and there were no BIFER-IFER proceedings because that is in respect of industrial undertakings only. Or even on reference, it is filed. What happens thereafter? My experience shows that real agony starts thereafter, as far as company's affair and liquidation proceedings are concerned. It is like in civil courts, when the decree is passed, in execution what happens, that kind of situation. Now, for liquidation, after this winding up and when the company is to be dissolved, it takes numbers of years. Doing business in its report, I said where it ranked India 137, it says that insolvency normally takes 4.3 years in this country, and I am happy if that is the situation even now, which is much improved, because I remember when I took over as company judge, there were 700 companies in Delhi High Court only which were under liquidation for a number of years, where liquidation proceedings were going on and endlessly. So, and final dissolution under 481 had not taken place. But 4.3 years also is a very, very long period when, from where I started, the interest of the creditors, which has to be kept in mind. We know the moment company goes into liquidation, creditors think that they are not able to get anything, particularly and apart from financial companies, those also which have, the security over the assets, that some mortgage or some other things are there by, with the banks. Otherwise, hardly any chance to recover. And from my experience, let me tell you, in many companies where official liquidators were able to salvage some of the assets, which process would take 5, 6, 7, 8 years. And after 8 years, if some corpus is there with the official liquidators, and now the notices are sent to the creditors that you come and take money, because many, for filing the claims would not come. Because in those 7, 8 years, trading creditors have particularly vanished. They didn't even know that they would be able to recover the money. Although such a situation would be in very few cases. But even in those cases, we found that in many cases that creditors would not come forward. They don't even know that this is the situation. And statement of affairs is not filed by the, I need not go into details, as company secretaries you know much better. Statement of affairs is not filed. Proceedings are taken, criminal proceedings are taken under 467 and 476, etc. But then they are hardly are culminated into any punishment, so there is no deterrent. Assets fritter away in the meantime. I remember the last case of malfeasance against the directors and asking them personal, this thing in 2005 or 6 I was there, was filed 20 years ago. And thereafter there were no such cases filed by the official liquidator. And I would say one of the reasons was appointment of official liquidators only. Because in our country, once the company is wound up, we have hardly any practice of appointing voluntary liquidators or liquidators who are private liquidators, which is more in other countries. You had this bank, very famous bank, Lehman Brothers. In 4 months' time, it was liquidated and liquidation was over. In 4 months' time. But it was achieved by the chartered accountants and company secretaries in that country, not by the official liquidator. Here, official liquidator who would be coming from the ministry, company affairs, who is not at all well versed with the company laws, because he is posted there. When he comes there, he starts learning. And then other things which they do, I need not go into that. So therefore, what happens, I still remember in one of the cases of, it was, I think, merger or amalgamation of the two companies, and that scheme was given. And whenever the scheme is filed for, we first have the meetings of the shareholders, creditors, etc. And as you know, under the provision, 75% of these shareholders and creditors of different categories, they have to approve, and then when it comes for approval, then the notice is normally sent to the official liquidator as well as the registrar of companies, that you have, if you have any objection, you file. I would see in the liquidation proceedings, the official liquidator's office was not able to file proper reply to 2 or 3 pages application filed by anybody. Number of opportunities would be given. I remember I had to summon the official liquidator so many times. I had to coerce, I had to coax him, I had to cudgel him. And when it would be this kind of scheme of merger amalgamation, a reply would be there running into 100, 200, 300 pages, impeccably typed, so well presented. I said in the court, I am saying very frankly here, said in the court to official liquidator that this is the reply which is given to you by the company itself and you are filing because your office cannot prepare such a reply. I mean, this is the harsh reality we know. Coming back to this, what I was trying to say was that liquidation proceedings take time. Now, what I wanted to say is it is because of so many authorities dealing with one subject. On the one hand, we have Company Law Board, on the other hand, we have High Court, and at the third place, we have the SICA, BIFR and IFR, which is contributing to the delays and so many other problems. Here, now, these are my reasons which I give in favor of NCLT. We have one single window now. It is the convergence of judiciary and administration. There have been many, much debate, I would say, as to whether there should be such tribunals. I am not generally talking of tribunals. NCLT, I'll come. And I still remember about few months ago, it was precisely in April, 5th or 6th April, when there was Chief Justice Conference. All Chief Justices, we have normally one conference in a year, organized by the Supreme Court, that is Chief Justice of India. And after these 2 days Chief Justice Conference, it is followed by Chief Justices and Chief Ministers Conference on the 3rd day. Because many resolutions are passed for the reform to be undertaken in the judiciary, service conditions, so many issues. But then the cooperation of government is needed because purse is still with them. So 3rd day, it is always Chief Ministers and Chief Justices Conference, so that they are able to what we discuss in the 2 days time and how the governments would now support. And the Prime Minister normally comes and he inaugurates. And President Modi there criticized tribunalization of this. I still remember. He said that I am given to understand that tribunals are not functioning properly in this country. Much is to be said about it, and that is correct. Whenever, and it was said, yes, I am a party to this NCLT judgment for reasons, in spite of knowing all this. I don't take credit. There was applause that I have given this judgment. That is not necessary, because I only did my duty, which I have to do as a judge. But this was mentioned, and what was mentioned by, I think, Mr. Chawla or again Mr. Satinder Singh, that look, there was some doubts about NCLT, particularly after NTT judgment. Mr. Chawla, you mentioned. And let me tell you, I am a party to that judgment also. We gave that judgment, and thereafter, this judgment, as far as NCLT is concerned, we said no, there has to be NCLT. It may be two reasons. One was judicial discipline, that earlier in 2010, Constitution Bench had already upheld the validity of NCLT, Justice Ravindran's judgment. But other reason was, and the reasons which I gave you, and from my personal experience, which I thought it is very necessary to have one window for all these, which is not there in text. The reasons were totally different. So therefore, what goes in our mind, and I'm sharing with that. So why? It's not a question of that one tribunal, yes, if we say that that is unconstitutional, other tribunal, we have to necessarily say that. We have to see the situation in each case. And in such cases, and particularly Supreme Court, and when the judgments are constitutional bench judgments, which may write the history for the nation, judges have to be visionary. They have to think what they are doing and how it is going to affect. I remember Justice Kapadia used to say that such cases, because he was an expert in taxation, so and taxation laws in any case, the judgments would be governed by economic considerations. But I am of firm view that law and economics has very, very close connection. And it is not confined only to commercial laws or tax laws. Law and economics will prevail even if it is a case, and that is my hypothesis. And if given a chance, I get a chance, I will develop and write it in one of the judgments, that how the judge should be influenced by these considerations which matter a lot. And any case, even if it is a case filed by a woman under section 125, claiming maintenance against the husband, how law and economics principles would govern, here the question is empowerment of women. And therefore it becomes important. I'm not going into those areas. This example I gave only to demonstrate that such considerations have to play a prime role. Not there either in the judgment of Justice Ravindran or in our judgment. But then, first thing I would say which is important as far as such disputes are concerned, and one window, and the message which I have given up to now, insofar as judicial or legal regime is concerned, as in respect of commercial disputes and other aspects, sick companies, turnarounds, etc., that we need an efficient, predictable and transparent system. There is no doubt judges in the High Court have been doing their function to their best of their capacity. CLB was doing, and I presume that BIFER-IFER were also doing, though the way SICA has been implemented in this country from 1986 till date, it is a very dismal picture it projects and gives. I think when the figures are given, there is hardly 5 or 6%, in 5 or 7% cases they have been able to achieve turnarounds. Proceedings go on there for years together. That is not the purpose. As I said, first thing is efficient, predictable and transparent system. Second is balancing, from what I have said, the creditor's right on the one hand and to protect the company on the other hand. So therefore, what is required in a situation like this? Whenever a company becomes sick, or whenever there is a winding up petition against a company, the first attempt is that this company is saved, it is revived. Even when the petition is filed directly in the High Court, though there are various judgments, the High Court straight away, I mean, most of these cases are under 433E of the earlier Act, inability to pay debts, would not wind up the company immediately. They will make an attempt if the company can be revived, even if it is become, as the distinction was sought to be drawn, and rightly so, between bankruptcy and the insolvency. But this process should not take time. We should be able to know within a very short period whether such a company is in a position to have a turnaround or not. Because this is the period which is the twilight zone for the directors. And the moment company petition is filed, and if it is a dubious company, with, I mean, in the sense with dubious directors, etc., or management, they'll start frittering away the assets before the winding up orders are passed. So therefore, this should not take time. But at the same time, during this period, how the management should run, how it should be taken over, if at all that is necessary, how another management should be introduced, new management, new directors should be there during this period. This twilight zone, as I said, is a matter which is very, very important, but time is the factor which is most important. And if turnaround is not achievable, it should be winding up and liquidation, like I told you the case of Lehman Brothers. That should be the situation. So that can be achieved only if it is one body which is looking into all these aspects. Generally speaking, I told you about the tribunalization. The factors which may be why we say that courts, it's a, what I'll say that it is technical experts on the one hand versus judicial wisdom on the other hand. When we talk of that the matter should be given to the courts only, and because there is a section which says that courts only, because they know that the judges have that kind of wisdom, that kind of expertise, that kind of experience, that they would be able to go deep into the merits of the case, and they are able to set higher standards of justice. That is correct. As a judge, I would say, definitely. But can every case be decided only on this basis? This very merit, higher standards of justice, becomes demerit in such cases, when process becomes a long drawn. Because every judge, I can speak for myself, and I know Justice Kumar, who is here, has also 15 or 16 years experience as a judge, that there is at the back of mind when deciding all types of cases, I'm not here confining this statement only to commercial matters, what we call sense of justice, which there is always an apprehension of intelligentsia who will speak for the courts and not tribunalization. They would say this would be lacking there. But the flip side is, as I said, this sense of justice, and this is the experience not only here, even in arbitration matters, that many cases of commercial matters are not to be decided only on the basis of strict legal principles. Many such cases need to be decided going by the ground realities, how the company is functioning, how it would function, and there the experience of experts becomes very handy. These experts may be in the form of company secretaries, they may be chartered accountants, they may be cost accountants, or other technical experts, depending upon the nature of the industry or industrial activity. There may be technical experts in that because it's a suppose chemical industry manufacturing some chemical goods, etc. So those who are chemical engineers and others, they may be, not that they would be part of members, but they will be able to give assistance. So that is required in deciding such cases. And let me tell you, a good judge would keep in mind all those, but then he is not an expert. Many times such cases come, suppose a case comes before me which has the nuances of accountancy. What I'll do? And personally speaking, I have some knowledge of accountancy because I was a commerce student. Suppose there is a judge who doesn't know anything about accountancy. Or I'm now sitting in taxation bench again and doing the cases of customs and apart from income tax, customs and excise, where the classification comes and the products, we have to see, go through the process of the product and whether it would be classified in this head or in that head. Many times, as I've never studied science, I may be at loss. So we may unofficially, if there is a friend of ours, may take some assistance. But why not that assistance on the bench by an expert member? And here, NCLT, the role of expert becomes important. Judge would be there. Judges, they are judicial members, they are technical members. So judicial members will keep in mind that sense of justice, they will ensure that. And many times when the case is decided by a tribunal or other authorities and it comes to the High Court or Supreme Court under challenge and what we call judicial review, though it is on very limited grounds, but sometimes otherwise a good decision, but procedural mistakes committed, say principles of natural justice not followed. A particular notice which should have been given is not given, the judgment is set aside on that ground. So judicial member will be able to take care of all these aspects. And he will be guided by the experts. So therefore, let us see, yes, now we have the new regime. I hope it works well. NCLT, of course, there are so many ifs and buts. And the first is, and the foremost, which is very, very important, is which we have to ensure that the persons who are appointed, they are good. It should not be why tribunals, other tribunals have failed. Wherever, again, I am very candid and blunt in my statement, whenever the appointments are made, because mostly these appointments in tribunals are of retired persons, as if it was to give them employment after their retirement and not on merits. Be it judicial members, be it administrative members. And let me be very frank in saying so here, I hope, as far as NCLT is concerned, we have cost accountants, we have chartered accountants, etc., who can become members. We have secretaries also. But it should not be again, because in such cases bureaucracy normally is able to prevail, that they induct only their people. Professionals from your bodies who are expert, and that is the purpose of NCLT, should be there. That is very, very important. And therefore, first and foremost requirement to make it a success, NCLT, would be good appointments. And the appointments of those persons who have expertise in this field, who had worked, if they were judges on the commercial side, they have expertise, and likewise those who are drawn from as administrative members from other sources which I mentioned, those who are good and persons of impeccable integrity. Because we have seen on papers there are many good laws, but implementation is not good because of various other factors which are extraneous and creep in. And I hope and I pray that as far as NCLT is concerned, that should not happen. And with all good wishes to Justice M.M. Kumar, I hope that after a few years, when we are discussing here the functioning of NCLT, we will be able to tell that, look, our country is rated in first 10 and it is not at 137 number today. So there's much expectation from NCLT. It is definitely a new era to corporate adjudication. And therefore I say good luck to the NCLT, which is going to, I think it should start functioning in, as it was rightly pointed out, that maybe the selection committee to select the members has already been constituted, I suppose. So they would do their work fast and NCLT should start functioning within few months. And more than that, my good wishes to all of you, as it is new era for you as well. So it is new era for the company secretaries, it is new era for the country. Thank you.
Thank you, Mr. Justice A.K. Sekhri and Mr. Justice M.M. Kumar for such a wonderful and mesmerizing address. And very much thank you for you have spoken from your heart and such a wonderful perspectives on operation mismanagement, SICCA, winding up, NCLT and CLB. I think audience, they must have enjoyed your addresses. I would now request the Secretary NIRC, Mr. Dhananjay Shukla, to please present a vote of thanks.
Good morning. At the outset, I acknowledge the presence of Sri Vineet Chaudhary, Central Council Member, Mr. Manish Gupta, Vice Chairman, NIRC, and Mr. Saurabh Kalia, Regional Council Member, Ms. Monica Kohli, Regional Council Member. We welcome you, sir and madam. Honorable Justice A.K. Sekhri, Honorable Justice M.M. Kumarji, other dignitaries on the dais, it is indeed an honor and I am humbled to be called upon to propose vote of thanks to Justice Sekhri and to Justice M.M. Kumar. On behalf of NIRC of the ICSI, on behalf of all of you, on my personal behalf, I express my sincere gratitude to Justice Sekhri for being with us and for sparing your very, very precious time and for guiding us, enlightening us. And we assure you, sir, that Company Secretary will play a very, very proactive role in achieving the objective of NCLT. We are thankful to you. I would like to request our founder president, Dr. R. Krishnan, to come forward and present a memento and green certificate to Justice Sekhri as a token of our love and respect. Please give a big round of applause. Thank you, Krishnan, sir. Thank you. We are also grateful to Honorable Justice M.M. Kumarji for being present here today. And let me add you, sir, that your presence here today has given a new motivation. And as a company secretary, we will be gearing up for taking up the challenges lying ahead. We are thankful to you. I would like to request Mr. Virender Ganda, past president of our institute, to come forward and present a memento and green certificate to Justice M.M. Kumar. Please give a big round of applause. Thank you, Ganda sir. I'm thankful to all the past presidents present here, all the past council members, past chairman of NIRC, past regional council members, present regional council members. I'm thankful to each one of you for joining this seminar. I invite all of you to join for the tea. This inaugural session concludes. That's what we are. Okay. Thank you. We'll continue with the session.
Request all members to kindly take their seats. We are going to start our technical session. Would request all the members present here to kindly take their seats.
यहाँ तो कोई नहीं रहेगा, डेस्क पे कौन रहेगा, ऑलरेडी लाइव चल रहा है।
May I request our learned speaker, Mr. Krishnendu Datta, to kindly come on the dais. May I request Central Council members Vineet Chaudhary, Ranjit Pandey, my regional council colleague Mr. Pradeep Denat to kindly come on the dais.
देख लीजिए।
Mr. Vineet Chaudhary, Mr. Ranjit Pandey, Mr. Pradeep Devnath to kindly come on the dais, please. We are going to start our technical session. Ranjit ji, speakers aa gaya na? He is here only. क्या sir? Ranjit. Good morning. Dignitaries present on the dais. Good morning, all of you. At the outset, I welcome all of you to the first technical session on the today's seminar, NCLT, a new era to corporate adjudication. As very rightly mentioned by Mr. Justice Sikri, that it's a NCLT new area for 2 company secretaries as well. We will be discussing various aspects relating to NCLT in this technical session. To start with, we have with us in this particular session, we will be discussing critical concepts concerning operation and mismanagement that will be taken by Mr. Amit Sibal, who will be joining us in a short time. He is stuck in a court hearing and he will be joining us within a few minutes, and we requested Mr. Krishnendu Datta to start with the session. Then convergence of SICA, peregrine shift to industrial sickness and rehabilitation, that will be taken up by Mr. Satwinder Singh, our Central Council member. To start with, we have with us Mr. Krishnendu Datta, who will be speaking on practice procedure in tribunals, aspect must know. This particular session is very important with respect to the company secretaries who are going to deal in day in, day out basis in the NCLT. Mr. Krishnendu Datta is having his own law firm with the name K. Datta and Associates. And this particular law firm is a full service boutique law firm recognized for providing its highest level of legal services in various fields of litigation and arbitration, corporate and commercial laws, real estates particularly. And he is a very senior advocate, very humble and polite, and used to appear before the various high courts and CLB on regular basis. We welcome you, sir, on this occasion. May I request Mr. Harish Vaid, our past Central Council member, to kindly come forward and present a flower bouquet. Former Vice President of ICSI as well, to welcome Mr. Krishnendu Datta. Welcome you, sir, in this situation. Would request each and everybody to kindly maintain silence. We are going to start our first technical session, and Mr. Krishnendu Datta will be speaking on the practical aspects of NCLT, one must know, relating to appearance and all. Mr. Krishnendu Datta, please.
ये फिर करोगे कैसे? बाहर आ जाएगी?
Yes, please.
Distinguished guests on the dais, speakers, colleagues, company secretaries and friends, I am happy to have this occasion to address this august gathering. It is my first time addressing the Institute of Company Secretaries, and more so at a momentous time, a time of change, and we are at the threshold of a new era in company litigation. We have heard Justice Sikri and Justice M.M. Kumar talk about the virtues of a single window tribunal to address concerns in corporate litigation, a tribunal which will take over and encompass three significant legislations that have been dealt with by three separate forums till now. We have the High Court, which deals with cases of winding up, cases of merger, amalgamation, schemes under 391 and 394 of the Companies Act. We have also the Sikh Industrial Companies Act and the tribunals constituted under that legislation, namely the BIFR, and the Appellate Authority, that is the IFA, which deal with matters concerning Sikh industries. And finally, we have the Company Law Board, which was established in 1991.
I'll request everyone to kindly sit down, please. Backside. Request everyone to kindly sit down, please. Have attention.
Sorry. I was mentioning the Company Law Board, which was established in 1991, which typically took up cases concerning oppression and mismanagement. It took up cases pertaining to rectification of share registers, etc. For the first time, we have a legislation, that is the new Act of 2013, which envisages a single tribunal, that is the National Company Law Tribunal, and an appellate forum constituted under that Act, which will hear appeals from that tribunal, to hear these three diverse category of matters. It is a new era of legislation in corporate laws, and we hope and we trust that this tribunal will function as efficiently as it is envisaged to do, and our corporate cases will be dealt with on an efficient and an expeditious note. With that background, I have been asked to address everyone on the aspects of practice and procedure. Let me start by talking about the fundamentals of a company petition and how it is to be presented in the forums. Let me start, before I go on to the slides, can we have the first slide? Let me start by giving an interesting example of how a petition should be drafted. This is something which happened to me recently. I was presenting an appeal before the High Court, before a division bench. When the matter was called out, and it was an important question of law, on an appeal which was hotly contested, we had unfortunately lost before the single judge, and we were in appeal before the division bench, and I was asked to open the appeal, address arguments when the appeal was first taken up. When we appeared before the division bench and I stood up to commence arguments, the senior judge looks at me and says, "Mr. Datta, do you know the road from Delhi to Shimla?" You can imagine my state of confusion. Here I was ready to go on with an important matter of company law. And I was ready with the facts and I was ready with the law. And the question that was put to me by the court was, "Do you know the road from Delhi to Shimla?" So I said yes, though I felt like saying, let us keep the road to Delhi and Shimla aside for a moment and get on with the matter. But since the judge had put the question to me, I had to answer it. So I said, yes, this according to me is the road to Delhi and Shimla. I broadly described the way. The judge looked at me and said, "But there is another road." I said, "I'm sure there are several roads, my lord, but this is the quickest and the shortest road that I know of." And so the judge looks at me and says, "Well, I'll describe the other road to you." So he explained to me a road which, if nothing else, would have taken 2-3 hours longer to traverse. So I said, "But my lord, that road is much longer, and it is an indirect road. It is not a short road, it does not lead to Shimla very quickly." He says, "Exactly. Now, Mr. Datta, please look at your appeal that you are presenting before me, and please explain to me why you have not addressed the central point in the first few pages of the document. Why have you gone on and on about the facts? Why have you gone on and on about various other aspects of the case instead of coming to the heart of the matter?" So I was taken aback. I thought in my mind that the learned judge is right. What should have been addressed as the central issue in the matter should have been put at the forefront of the petition and should have been immediately available to a court to read. we must not lose sight when we draft a petition that a judge has to deal with 20, 30, 40, 50, 60 matters a day. And we lawyers, as a habit, are attenuated to making petitions bulkier and bulkier than the last one. We file pleadings, we file documents, we make the brief as voluminous as possible. I think sometimes with the mistaken impression that a voluminous paper book would present to the judge that the case is very important and it must be dealt with. I think that statement from the learned judge of the division bench opened my eyes to the value of concise pleadings, of short pleadings, of pleadings which must be to the point, pleadings which must not beat around the bush, pleadings which must tell the judge in the opening 5 pages of the petition that this is the issue the court has to deal with, this is the fact, and these are the legal submissions on that fact. I promised the judge that day that the next time onwards that I appear in his court, I will ensure that the appeal that I present before him would be short, would be concise, would be to the point, and would not beat around the bush. I hope to keep my promise going forward. But the point that I wish to make is that when we draft a pleading, we must ensure, and this is something the CPC mandates. Now, the rules of pleading, as have classically evolved, are mainly in the Code of Civil Procedure. Neither the Company Law Board regulations, nor the Company Court rules, nor indeed the Sikh Industrial Companies Act or the rules framed thereunder define how a petition has to be presented, drafted and presented. It is only the CPC which gives a guidance. The CPC says the petition must only state material facts. Nothing more, nothing less. Unless you have cases which deal with fraud, unless you have cases which deal with undue influence, unless you have cases which deal with coercion, where the statements on the pleadings, on the facts, must be stronger, must be in more detail, must explain to the judge how you are alleging a fraud, how you are alleging an instance of oppression, how you are alleging an instance of undue influence or coercion. I have seen suits which are in matters which were filed many, many years ago, and I have seen plaints which run only into a few pages. We mistake, sometimes when we draft pleadings, sometimes when we draft petitions, we are, if I may use the word, over-enthusiastic. We not only state the facts, we not only state the material facts, but we state all the facts. We state the background, we state the foreground, we state the grounds, we even make submissions. Now, typically all that is not required, but we have gotten into a habit of doing that. What I am trying to emphasize is that a petition which is concise, in my submission, in my opinion, would appeal to a judge more, would appeal to a member more, would appeal to a judicial mind more than a petition which is a rambling petition which goes on and on and on and goes into several pages, 20, 30, 40, 50, 60 pages, supported by documents. So what I am trying to emphasize is, let us try and keep the petitions short. The facts stated must be material. We need not repeat facts. We need not repeat submissions. Now, typically in a CLB petition, there is a form which prescribes how a petition must be drafted. That form also mandates, and this is one important aspect of CLB drafting, this is an important aspect of High Court drafting so far as commercial matters are concerned, and in matters relating to the SICA, that the acts, whether it is in relation to a Sikh company, whether it is in relation to a company that is to be wound up, or whether it is in a petition of oppression and mismanagement, must specifically set out the grounds of oppression and mismanagement. There is a recent matter in which I was appearing in the Company Law Board, where this instance was highlighted. It was drafted by a gentleman who was not proficient in commercial matters. He was not a company lawyer. He didn't have much experience in CLB litigation. The petition that came to me to argue had a rambling narration of facts, dates, events, they were all there by and large. However, what was not crystallized in the petition were the instances, according to the petitioner, of the acts of oppression and mismanagement. When the matter came up, I suggested to the client that let us file a petition for amendment. Let us bring the facts in order. Let us highlight the instances of oppression and mismanagement. We did that. We did that. An objection came from the other side, that look, you are bringing in new facts. You are bringing in new grounds. You are bringing in new instances which were not there in the petition. We then argued and argued successfully before the Company Law Board that the basis, that the bedrock, the foundation of the allegations, of the facts leading to the allegations are already there in that petition, that rambling petition. However, what we have done by way of amendment is to bring into focus the acts of oppression and mismanagement which need adjudication by the Company Law Board. So therefore, in specialized tribunals where the members who deal with these matters are also specialized, they have knowledge in this field, it is always good to highlight the acts of oppression and mismanagement and the acts, for instance, in a company petition, in a winding up petition before the High Court, one has to demonstrate before the court typically that a company is liable to be wound up, and in a vast majority of cases, it is the prayer for winding up is sought on the ground that the company is unable to pay its debts. There are other grounds which are pleaded. One is typically that it is just inequitable to wind up a company, but the vast majority of cases deal with matters where the company is unable to pay its debts. And in those matters, in those petitions, it is important to state candidly, categorically, and unequivocally that this is, according to us, that is the petitioner, the liability or the debt of the company which it is unable to pay, and this is where that company has admitted its debt. That pleading is very important. Similarly, in cases of Sikh Industrial Companies Act, one has to demonstrate before the tribunal that the company's net worth has been eroded. Those pleadings, those facts, those documents are of paramount importance. What I am saying is, what I am trying to address is, while keeping your petitions, drafts of the petitions concise, while stating material facts, one has to bring out those facts which are important given the nature of the plea, given the nature of the petition, and given the nature of the reliefs that you are seeking. Now, typically we find in CLB petitions that the law that has evolved is that the petition must state a series of acts, continuous acts of oppression and mismanagement leading up to the date of the petition. That was the classical view. That was the view taken by the Supreme Court in '65 in Kalinga Tubes. There was one line of thought that the CLB is precluded from looking at subsequent events. That the CLB, when it takes up a petition of oppression and mismanagement, must only be concerned with events which have transpired up to the date of the filing of the petition. That view has, of course, fortunately changed. The law now says, and there is case law on this, substantial case law on this, that the Company Law Board, as indeed the High Court and the other tribunals, must take into account subsequent events, if not for adjudicating the aspects of oppression, mismanagement, or winding up, as the case may be, but also to ensure that the relief which is ultimately granted to the petitioner is granted in light of the facts which stand on record when the petition is decided, when the tribunal decides what is the relief to be granted to the parties. That is a view that has evolved. Can we have the next slide, please? There are other formalities, of course, in relation to the form of filing petitions. I don't need to go into that. I think those are sufficiently stated in the rules and the statutory forms that accompany the rules. Let me address now on an area which is also of significant importance, that is the reliefs. Once your petition is drafted, once the material facts are stated, once the grounds are set out, whether it is of oppression, whether it is of winding up, whether it is in relation to a Sikh company, one has to turn to the aspect of what reliefs you can claim from the tribunal. Now, typically, we talk about two reliefs, two kinds of reliefs when we frame the reliefs in the petition. One is an interim relief, the other is the final relief. The interim relief is something you would talk about as a relief you would claim as an interim measure, as a relief which would ensure that the rights of the parties are balanced and the interest of the petitioner is protected till the final adjudication of the petition itself. The final adjudication of the petition would result in the final reliefs. So therefore, there are two distinct and different categories. The interim reliefs are reliefs which will continue to operate during the pendency of the petition, which will then culminate into a final order and the grant or refusal of final reliefs by the tribunal. Now, two or three important principles to be kept in mind while framing interim reliefs is that, number one, you should not ask for any interim reliefs which are not in aid of your final relief. In other words, your interim reliefs must be confined to what you claim finally. The benchmark of interim reliefs, as has been settled judicially several times over, is really to preserve and protect the rights of the parties during the pendency of the petition. And they should never exceed the final relief that you claim in the petition, nor should they, as a matter of fact and prudence, result in grant of the final reliefs. One can ask for a final relief, one can ask for the same relief as an interim relief, but as a matter of prudence, a tribunal or a court would never grant an interim relief which results in grant of the final relief. These are a few principles which must be kept in mind while framing interim reliefs. As has been settled as far back as in 1990 by the Supreme Court, interim reliefs are framed to preserve the last non-contested status. Now, in interim reliefs also, there are two categories. One is an interim mandatory injunction, one is an interim negative injunction. The difference between the two is this, that a mandatory injunction mandates or directs the other side, the respondent, to do something positive, as an interim measure. A negative injunction, on the other hand, restrains the respondent, the other side, from doing a positive act. Suppose you had filed a petition for operational mismanagement, you are a minority, and you feel that the majority who is in control of the company is about to sell an important asset of the company. You would typically pray for a restraint, that is a negative injunction, restraining the respondent from selling an asset, preserving that asset in the company till a final decision on the petition. The other category, as I said, is a mandatory injunction, where you would command the respondent to do something. Take a simple example. A company has defaulted in filing of statutory returns for several years. There is apprehension that prosecution would be started against the directors. As an interim measure, you could go to the company law board or to a company court, or in this case, the NCLT when it comes, and say, please direct them. Please direct the company as an interim measure to complete its statutory filings, to protect the company from exposure, to protect the directors from prosecution. That is a mandatory, interlocutory mandatory injunction. I must hasten to add that when the case law was settled so far as these two categories of injunction are concerned, the courts have felt that when you ask for a positive direction as an interim measure, you must plead a higher degree of proof, a higher degree of documentation, a higher standard of pleading to be entitled to a mandatory injunction, because then you're asking for a positive direction from the court, commanding the respondent to do a certain act, versus restraining the respondent from not doing a certain act. Now, that is so far as interim orders, interim reliefs are concerned. If we go on to the aspect of final reliefs now, typically in a petition for operation mismanagement, as opposed to others, in a case of winding up or in a case of a sick industry, when the matters go to the tribunals. In a case of winding up, the final relief can't be anything more than the winding up of a company. Unless, of course, the matters are resolved in between, the company pays the debt, the petitions withdrawn, put to an end. Similarly, in the case of a sick company, the tribunal has to decide whether a scheme of revival, once framed, will succeed or not. If it does not succeed, the matter has to be referred back to the High Court for winding it up. If the scheme succeeds, of course, then the company is revived, the matter is put to an end. As opposed to these two categories of matters, the scope of granting reliefs in an operational mismanagement action is much, much wider. In fact, it is one of the few legislations I have seen, Section 402 of the 1956 Act, as interpreted by the courts, which grant to the tribunal an incredible power to grant any relief which may ultimately aid the company to survive and which may ultimately aid the disputes between the shareholders to be sorted out. I have not seen this kind of power in any statute or conferred on any tribunal so far. The CPC, that is the civil courts which are bound by the CPC, are mandated to grant or not grant only those reliefs which are prayed by the plaintiff before the court. That is typically the case in all tribunals. It is only the Company Law Board, and now, of course, going forward, the tribunal, which has this power to mold, to grant, not grant. You may ask for 5 reliefs in your final prayers. The Company Law Board and the tribunal going forward has the discretion to say, well, in the facts of this case, keeping in mind the nature of the acts of oppression mismanagement, keeping in mind the status of the parties, the situation of the company, which may change from the time that you file the petition to when the matter is finally decided, I decide not to grant any of these reliefs. In my wisdom, the tribunal may say, the CLB has often said, I feel that a 6th relief is the most appropriate relief to be granted to the parties. Now, the guiding principle being that the relief which is granted should put an end to the disputes once and for all. Let me give a simple example. You have 2 groups of shareholders who are fighting. They are practically evenly matched. In a paid-up capital, one group, that is the petitioner group, may be holding 30-odd%. The respondent group may be holding 35-odd%. The remaining may be held, the remaining shares may be held by people who are not interested in the fight, by neutral shareholders who have no axe to grind, who have no personal affiliation with any of these, either the petitioner group or the respondent group. What happens? Typically, the first prayer in a 397, 398, that is an oppression mismanagement petition, says, please frame a scheme. That's typically what we have seen when we draft a petition, that the first prayer that is presented to the Company Law Board is, please frame a scheme to ensure efficient administration of the company. According to me, it is a prayer which is often sought, but which is a prayer which is extremely vague in its contours. How does the tribunal decide what to do? When faced with such a petition, what does the tribunal do when it is finally hearing such a petition? What is the relief that is to be granted, which will ensure that the company goes forward and the disputes are finished once and for all? Ultimately, as we all know, the tribunal's first and most important function is to protect the interest of the company. Keeping that in mind, what does the tribunal do? Suppose you have 3 prayers, none of which have anything to do with the final relief which will aid the company going forward and which will put to an end the matters complained of. The tribunal then may say, you have asked for framing a scheme of administration, you have asked for equal representation on the board of directors, you have asked for annulment of certain minutes of meeting in a general meeting or in a board meeting, you have asked for filing of statutory documents, you have asked for cancellation of deeds of sale, but going forward, is that the final solution? Or is the final solution something which I have to work out, given the status of the parties, that here we have two groups of parties, two groups of shareholders who are warring at war with each other, and to put an end to this, one group must leave the company. The earlier view was, and this is very interesting as to how the case law has devolved, which only shows that the court's functioning is dynamic. The court's functioning in our judicial system is dynamic, fluid, changes from time to time. We had a traditional view, which was there in the 1960s and 1970s, where the courts felt that to succeed in a petition for oppression and mismanagement, as opposed to winding up and say companies where there are fairly straitjacketed matters, you have to first demonstrate that there are acts of oppression and mismanagement. You have to then demonstrate that it is just and equitable to wind up the company. Only if you cross these two thresholds, then can you ask for the relief that you have prayed for in the petition, and then only will the tribunal look at the relief that you have prayed for in the petition and consider which of the reliefs are to be granted. That view has changed over a period of time. It started with the case of Needle Industries in 1981, where the Supreme Court said, three-judge bench of the Supreme Court said, that look, given a situation, it could be that the petitioner is not able to make out a case of oppression mismanagement. But should we leave it at that? Should we then say, all right, the petition is over, the petitioner has not made out any of its allegations, let us go home? That can't be. Because the company's interest is at stake. So we have to ensure that going forward, these disputes between the two shareholders are put to an end. Therefore, a law was evolved, which has now been strengthened in repeated judgments. Gaikwad said it, Radharaman said it in 2008, all Supreme Court judgments, that even in a case where the petitioner fails to make out a case of oppression mismanagement, the tribunal is not powerless to grant reliefs, to put an end to the matters complained of, to bury the disputes between the shareholders once and for all, so that, and this is typically in our system where many of the companies are still really corporate entities functioning in the guise of quasi-partnerships, where family members control shares, where the stakes of the shares are divided equally between various members of the family. In these situations, this kind of power is very important to be used by the tribunal to put to an end the matters complained of, even though a petitioner may not succeed in proving the allegations in the petition. Typically, consider a case of a minority shareholder, a hopeless minority shareholder, someone who's just about has the qualification to approach the company law board. The company is in the control of the majority shareholders. The documents, papers, evidence are in their control. The minority has no access to it, except for limited rights of inspection which a shareholder may have. What happens? He may file a petition for oppression mismanagement. He may make out a case. His allegations may be correct, but he may not have documents. He may not have proof. He may not have the evidence to bring home the charge. Does it mean his petition must be dismissed? No. The CLB has the powers to grant inspection to a shareholder once a petition is instituted, which go beyond his rights provided by the Act. In other words, a shareholder has a right of inspection of only a limited number of documents of the company. But once you're in dispute, once you're able to make out a case before the tribunal and the company law board can direct inspection of documents which otherwise would not have been made available to him, so that his allegations, which are prima facie strong, which prima facie make sense, are strengthened and is able to prove them. So a final outcome of the petition can be brought about. So these are the two categories of reliefs. One is interim, one is final. I've explained the distinction between the two. Now if we go on to the third aspect of the tribunal, which is the powers, which I have also touched on very briefly. That is the power to do complete justice. And this is a power which the CLB has under Section 402, which is not, as I said, guided or controlled by the prayers sought by the petitioner. The CLB has vast powers that has been recognized in a number of judgments, from overriding the articles, from annulling contracts, from directing buying and selling of shares, from directing restitution. Suppose a petitioner is able to bring home a charge that the respondent group has been responsible for diversion of funds, for siphoning, for illegal sale of assets. There is a restriction under 402 that if a property of the company is transferred out, that transfer can be challenged by the petitioner, but only within 6 months of the date of transfer. That's a provision under 402. Typically, a petitioner may not know that such an asset has been transferred. He may come to the CLB after 6 months. Does it mean that the tribunal is powerless or the Company Law Board is powerless? Certainly not. The Company Law Board in a situation has the power to direct restitution, if not cancelling the sale, of directing restitution to ensure that the company's interest, that is the loss to the company, is compensated by the person who has done such an act. The Company Law Board can appoint chartered accountants, company secretaries, valuers, to value experts really, which powers it may itself lack, to value the extent of diversion, to value the extent of siphoning, to value the extent of loss caused to the company, and on the strength of that valuation report, direct restitution to the company, direct recompense to the company, direct that the company's loss is made good by the persons responsible for causing such loss. Similarly, it can direct buying and selling of shares, as it often does, to put to rest the matters between the two groups of shareholders. Valuation is carried out, exercise of valuation is carried out, and one group is typically told to buy out the other group. Typically, it is the majority, though there are instances of cases before the tribunal that where a majority has been proved to be indulging in severe acts of oppression and mismanagement, particularly mismanagement, running down the company, causing losses to the company. In that case, a minority can also be asked to buy out the majority. But the thumb rule is that normally the majority buys out the minority. The thumb rule also is that when considering a situation of buying and selling, the expertise of the parties to run the business must be kept in mind. In other words, you have two groups of shareholders, maybe they are evenly matched. However, the company has a specialized business. One group is well versed with their specialized business. One group is able to run the company better. When directing buying and selling, that is an important consideration for the tribunal to keep in mind as to which group will buy out the other. These are considerations which will be kept in mind always while granting the final relief. And as I explained before, the powers of the tribunal are not limited to the reliefs sought by the petitioner. It can go much beyond them. It can ensure that reliefs are granted which are not prayed for, but which are necessary to put to end the matters complained of. After this, let me briefly touch on certain aspects of procedure, which are important when we are dealing with matters in the tribunal. Typically, there are cases of amendment of petitions, which is an important matter which is considered. Before that, let me turn to the aspect of review. The Company Law Board, unfortunately, doesn't have the power of review. The power of review is a power granted to courts and to tribunals to review their own orders. Typically, the grounds of review which are provided under the CPC are that there are certain important matters, documents, facts, which were not placed before the court or the tribunal when the matter was heard, resulting in an error of the order and if those documents had been available, maybe the order would have been different. Those documents have been discovered after the order has been passed, but they have a bearing on the matter, have important bearing on the matter. In such cases, the petitioner can request, or any party can request the court by way of an appropriate amendment application, review application, to take into consideration those documents and then consider the order, that is, review the order. The other aspect is where an error is made, which is evident on the record, by the court, by the tribunal, which error can be rectified by filing a review petition. These are typically the cases, the classical cases where a review petition is entertained. However, as I said, the Company Law Board does not have the power of review. That is a deficiency which should have been made good by way of an amendment long back, I feel, because reviews are not, the power of review is not considered, and it has been settled, is not considered to be an inherent power, a part of an inherent power of a court. The power of review has to be conferred by the statute. Where the statute does not confer a power of review, the court or the tribunal cannot exercise a power of review. In other words, even an error apparent on the record, or even the subsequent discovery of documents, have to be taken up and placed before the appellate court, which will then have to consider it. That's a shortcoming in the Act, which should have been rectified but has still not been done. Now, turning to the aspect of amendment, as I was explaining earlier, there are petitions which are sometimes not happily drafted, not happily worded. They would require rectification during the course of proceedings to frame the petition better, to incorporate classically subsequent facts which have arisen during the course of petition. We all know our judicial system is a bit slow. Petitions take time to get disposed of. When you start a Company Law Board petition, when you start a Sikh Industrial Companies Act petition, when you start a winding up petition, a certain situation of facts may be prevailing. However, company is dynamic, it continues working. Things happen, events transpire, subsequent events take place, which then have to be brought to the notice of the court, which is finally going to adjudicate the matter on the basis of the facts really existing when the final reliefs have to be considered for grant or for refusal. In such a case, how does one bring them on record? The CPC says that you must amend your petition, you must amend your pleadings to bring on record subsequent events, and the courts are liberal. The courts are, the law of amendments is fairly liberal insofar as plains and written statements before a civil court is concerned, and the court can always consider and allow an application for amendment to bring on record subsequent events. The two thumb rules of where an amendment petition or an amendment application is disallowed is typically a case where you are either seeking to change your case completely. In other words, you may have pleaded a certain cause of action, a certain case. However, by way of amendment, you try to do away with that case and introduce an entirely new case or a new cause of action. The courts typically say that you can't do that. The other thumb rule is, in relating to amendments, is where a certain admission is taken on record, is made in a pleading. Suppose I file a petition, and the respondent makes a statement that yes, on 10th of September 2014, I withdrew 25 lakhs from the company. I used it for this purpose. Along comes an amendment application after a year or a couple of years, where the respondent now seeks to amend its reply or its counter affidavit and withdraw its statement in relation to that withdrawal of 25 lakhs. Would a court permit this kind of amendment? Typically, no. Because that statement, that original statement constitutes an admission on fact. And once you've made an admission on fact, you cannot be allowed to withdraw it. The courts, however, are lenient enough to permit an explanation. Suppose you want to explain under what circumstances those 25 lakhs were withdrawn. That amendment is permissible. However, what is not permissible is the total destruction of the original statement or admission and its replacement with an entirely new stand. Those are typically the 2 or 3 thumb rules of pertaining to amendments of pleadings before the courts and tribunals. The courts have held, and it is consistently settled, that even that a petitioner or a respondent or a party before the court can take inconsistent stands. In other words, you can plead A and in the alternative plead B. You can plead a certain statement and then say in the alternative, assuming that statement is not correct, then this is what my stand is. That is permissible. What is not permissible is a total destruction of stands. That is a mutually destructive stand. Let me give an example. There was this matter which came up only last week in the Supreme Court, where an appeal was filed against an order of the High Court, where the High Court refused the amendment. The original plaint was filed for partition of immovable properties. There were 3 branches of the family. Written statements were filed by all the remaining 2 branches. One branch was the plaintiff, the other 2 branches were the defendants. In the written statement, one branch of the family said, look, so far as this property X is concerned, I have given up my claims long back, and I have no right, title or interest of any nature in that particular property. In the case at hand, where I was appearing, as we all know, cases take a long time to finish. Property prices go up. Properties which were not valuable 20 years earlier or 15 years earlier become valuable subsequently. The thinking of parties change. They may now feel that, oh, why did I make that statement in 1985 where I said I have no right in that property? That property today is a valuable property. Let me try. Let me make an amendment application to the court and make a statement that, look, that was a mistake. That statement in the original written statement was a mistake. And I have a right in that property. This is what happened in that matter. We argued in the High Court, and we argued successfully, that the original statement constituted an admission. It is not a case of a plea which is an alternative plea. There can be no alternative plea to a plea that I have no right in a property. That was a case where you're seeking to withdraw an admission which you have made, and you are seeking to bring in a new case, maybe 20 years after the original case started. That is the kind of example where an amendment should not be allowed, where an amendment actually destroys the foundation of pleading of a party and seeks to introduce a new case after a passage of time. It seeks to cause prejudice to the plaintiff or the petitioner because he has a right to rely on the admission made in the original pleading. And that right is lost to him if the amendment is allowed. We hope to succeed in the Supreme Court. The matter is still being heard. Now, going on to the next aspect of practice and procedure is the applicability of the 2 fundamental statutes which govern procedure in the civil courts and in the criminal courts, which is the Code of Civil Procedure and the Code of Criminal Procedure. As we all know, proceedings before a civil court are guided procedurally by these 2 statutes. However, in strict sense, neither the Code of Civil Procedure nor the Code of Criminal Procedure is applicable to the tribunals unless, of course, the statute makes it so applicable. For instance, in the 1956 Companies Act, Section 10, a particular subsection of Section 10, lifted some of the powers of the CPC and conferred it on the tribunal, that is the Company Law Board, as it did insofar as the CICA is concerned. The winding up court, for instance, on the other hand, that is the High Court, the Company Court rules, Rule 6, clearly provided that in case there is a lacuna in these rules, that is the Company Court rules, and there is a matter not provided for, then the CPC will apply, and expressly so. So there was a little difference. Whereas the Company Law Board only had certain powers of the CPC which were limited to 4 or 5 provisions in relation to matters of trial, in relation to examination of witnesses, in respect of issuing commissions, in respect of a couple of other matters. The company court, that is the High Court, the company bench of the High Court, had powers of CP wherever there was a lacuna in the company court rules. Now, there is a positive and negative. The Company Law Board, therefore, when it functions and it decides a petition for operation mismanagement or for rectification or some other matter, is not fettered, not bound by these procedures, which are mandated in the CPC. It has flexibility. It has a flexibility to evolve its own procedure. It has flexibility to ensure that a lot of procedural delay, which takes place in a civil court or a criminal court, does not hamper its functioning, does not impair an expeditious disposal of matters. However, the guiding spirit, there is only one guiding spirit, which is that the principles of natural justice must be adhered to while framing a procedure. In other words, the tribunal has the power to frame its procedure, has the power to do away with a lot of procedural red tape, to cut through a lot of procedural maze, reach a conclusion faster, but while doing that, not lose sight of the principles of natural justice. In other words, not lose sight of the fact that both parties have an opportunity, must have an opportunity of presenting its case fully. That is the guiding benchmark. Let me give an example. Typically, in operation mismanagement matters or in the winding up court or indeed in the BIFER or the IFER, oral evidence is not recorded. People proceed to file petitions supported by affidavits and documentary evidence and proceed to argue the matters on the basis of these statements on affidavit. In a civil court, on the other hand, in a civil suit or in a criminal proceeding, a trial is conducted where parties are allowed to present their witnesses to prove their statements, and the other party is given an opportunity to cross-examine those witnesses about their credibility, about their statements, about the veracity of the documentary proof they're relying on, etc., etc., to try and bring about, to arrive at the truth, to test the matter. The tribunal typically doesn't do that. The CLB very rarely does that. But does it mean that it does not have the power? The answer is no. Tribunals have power to record evidence. As I said, the 1956 Act, and I believe a provision in the 2013 Act, also clearly confers powers on the CLB and the NCLT to record evidence. Why does it not do so in every matter? We hardly see a trial being conducted before the Company Law Board. The reason is also simple, as I believe there's a few judgments of the Company Law which explain the reason. The reason is that normally the allegations in a petition, in a company petition, are based on documentary evidence, statutory records, public documents which are available. One can argue that a particular inference drawn from a document is incorrect. One can argue that an interpretation of a document is X and not Y. But normally one can't dispute the existence of those documents. That is the rationale given by the Company Law Board to say that in most matters trial is not necessary. However, that is not, as I said, the final conclusion. Those very judgments also say that if necessary, certainly trial can be conducted. There is one view of the CLB which says that the moment you ask for trial, the moment the matter goes into disputed questions of fact, the CLB should withdraw its hands and should relegate the parties to a civil court where a full trial is conducted in accordance with the CPC. In my opinion, and that's my personal opinion, that view is not correct. A specialized tribunal, as the Company Law Board is and as the NCLT will be, must deal with the cases which come up before it, which fall within its jurisdiction. Assuming a trial is to be conducted for examining the veracity of matters which require trial, which require cross-examination, then that must be done. No court, no tribunal is powerless to record evidence and to conduct a trial. And going forward, that is something that should be done. Now, apart from this, there are various other procedural matters, as I explained, principles of natural justice, powers of discovery, inspection, etc. They are all available to the tribunals. The orders of the tribunal and of the CLB can be executed as decrees of a civil court. In other words, they attain finality, of course, unless they are upset in appeal, and they can be enforced in accordance with how decrees of a civil court, the final judgment and decree of a civil court is enforced. There are exhaustive provisions in the CPC relating to attachment, etc., which can be enforced by the tribunal. Similarly, as I explained, in strict sense, the Evidence Act is not applicable, the provisions of the Evidence Act. However, the guiding principle is that the rules of evidence must be adhered to. And the tribunals endeavor to do that. As I explained, the reason is that most often petitions for oppression mismanagement are based on statutory records, and such records, the existence of such records is not typically disputed by parties. However, where no conclusion can be drawn on the basis of that record, most certainly the tribunal has the power to record evidence, and I think it should not shun its responsibility, withdraw its hands, and should ensure that evidence is concluded before itself. Powers of contempt, again, as I said, the Company Law Board, of course, could pass orders to prevent abuse of its process. However, they did not have the powers of contempt, to punish for contempt, that is, for punish for non-compliance of its orders, which the High Court has. And a matter would be referred to the High Court when an issue of contempt would be raised before the tribunal, that is, non-compliance of the orders. The matter would be referred to the High Court for adjudication. Now the new Act makes a departure. The tribunal will have the power to punish for non-compliance of its orders, and that is very important. Sometimes it so happens that parties take advantage of the fact that a tribunal does not have the power to punish for disobedience of its orders, and it knows the matter has to be referred to the High Court, where a judge sitting and deciding the matter is not the same judge who passed that order and who saw its order being disobeyed. Psychologically, it makes a difference. People take advantage of it, but that lacuna has been now done away with the new Act. The tribunal has the power to punish for contempt and to ensure that its orders are complied with by the parties. Typically, of course, in contempt jurisdiction, the two, again, benchmarks, the thumb rule is that if the jurisdiction has to be sparingly used, it has to be cautiously used, it has to be ensured, it has to be used only in cases where the disobedience of the order of the tribunal is deliberate and willful. It is not negligence, it is not oversight, it is not inadvertence, because the powers of contempt have severe consequences. There can be conviction, imprisonment, attachment of properties, detaining, civil prison, etc., etc. There is also case law which says that if two views are possible, in other words, if an order can be interpreted in more than one way, an interim order can be interpreted in two ways, and a party has interpreted it in a certain manner, though that may not be the interpretation of the order which was in the mind of the court or of the other side, then that party is not guilty of contempt. His conduct is not mala fide, it is not a deliberate and willful act. It is something which he has done bona fide on the basis of an interpretation which may not be the correct interpretation, but is certainly an alternate interpretation, as something which he could have bona fide believed to be so. Now, if we move on to the aspects of maintainability and the arbitration agreement, both two very important aspects which come up before the tribunal very often. Section 399, the existing 399 of the Companies Act, requires a certain threshold qualification, as it were, for a petitioner to approach the Company Law Board. The requirements for a winding up petition and a petition under the Sikh Industrial Companies Act are also in place. Typically in winding up, as I said, one has to demonstrate before the court that there is an admitted liability of the company to the petitioner, and that liability has been admitted in some manner. One would expect documentary evidence of such admission. Insofar as Sikh Industrial Companies Act is concerned and the functioning of the BIFER is concerned, the petitioner approaching the BIFER has to make out on the basis of documentary evidence, on the basis of statutory records, that its net worth has been eroded. Only then will the tribunal exercise jurisdiction to proceed to hold an inquiry, that is the BIFER, proceed to hold an inquiry and then appoint an operating agency to frame a scheme of revival and then test whether that scheme of revival can run or not. So far as the Company Law Board is concerned, the threshold, the qualifying for a petitioner or a group of petitioners to approach it is 1/10, as we have mentioned in the slide. The members applying should hold at least 1/10 of the paid-up capital or constitute 1/10 of the total number of members of the company. That's the threshold. If you don't attain that threshold, it does not mean that your remedy is barred. You can always approach the civil court. That remedy is not shut out to you. However, issues arise very often in cases, and I'm sure we have all experienced that, where assuming a member was 20% or 25% or 30% at a certain given point of time, as a consequence of an act of dilution, as a consequence of issue of further shares, as a consequence of allotment of further shares, or as a consequence of transfer of his shares, his shareholding is brought down to say 5%, 6%, 7% below the threshold. Would it mean, and these are the very acts that he wants to assail before the Company Law Board in a petition under 397, 398, would he mean that he is disqualified? The answer has to be no. This law has been evolved, it has been settled, that one must look at the qualifying mark, that is the 10%, before the acts of oppression, mismanagement, as have been alleged to have been committed, have actually been committed, and as a consequence, his shareholding has been reduced below that qualifying mark. So therefore, it is from that perspective one must look at that qualifying mark, that qualifying threshold, that qualifying standard, and petitions which have been filed by petitioners whose shareholding initially much higher than 10%, which have been brought down below 10% as an act of oppression or mismanagement, are entertained by the Company Law Board, even though objections may be raised that the petitioner does not meet the qualifying 399 standard of a 10% threshold. But those pleas are rejected. The other aspect which has evolved in recent times is in relation to arbitration agreements. As corporate law has evolved in India, as the corporate world has gone, there have been joint ventures, business tie-ups, joint venture entities which are formed, shareholders agreement which are signed between two shareholders who come forward for a common purpose to run a particular enterprise, to run a new business. They form a joint venture company, they sign a shareholders agreement. The terms of that shareholders agreement are incorporated in the articles typically. Very often, as we find, those shareholders agreements, those share purchase agreements, those articles contain arbitration agreements. So therefore, one possible argument which has been raised in matters going forward in the recent times is that, look, where the shareholders have envisaged an alternate dispute resolution mechanism, that is an arbitration, would the CLB still be entitled to exercise its jurisdiction under 397, 398? Or would a winding up court be entitled to exercise its jurisdiction to wind up a company, despite the existence of this alternate mechanism which the parties themselves have put in place? This was a question which has come up from the 1990s, which is still a vexed question so far as the CLB is concerned. So far as the winding up court is concerned, the Supreme Court settled the matter in 1999 by saying, look, no arbitrator can exercise the powers which are given to a winding up court. The powers are vast. No arbitrator can ensure that a company can be wound up in accordance with the provisions of the Companies Act. That's a specialized jurisdiction which is vested statutorily in the company court, and that jurisdiction cannot be given to an arbitrator. So far as winding up is concerned, that matter was settled. Similarly, so far as SICA is concerned, it is quite clear that no arbitrator can exercise a jurisdiction to determine whether a company is sick or not and in what manner it is to be revived. However, so far as the CLB is concerned, the provision is this aspect is still a little grey. There are case laws on both sides. There is case law to say that if the disputes between the shareholders arise out of the share agreement, or that is the share purchase agreement or the joint venture agreement, then the CLB can say, look, you have decided, both of you shareholders have decided to have your dispute settled in arbitration, please go there. There is equally an opposite case law, volume of case law, body of case law, where the CLB has said, in fact the high courts have said, that the powers granted to the Company Law Board under section 402, that is the power to grant final relief, and 403, the power to grant interim relief, are so vast and so specialized that it can't be subject matter of an arbitration. In other words, those powers can only be exercised by the tribunal, and therefore, despite the existence of a tribunal, despite the existence of an arbitration agreement, the tribunal should be entitled to proceed with the matter. This, from what I remember, there is no authoritative judgment of the Supreme Court on this point, and we look forward to this aspect of the law at least being settled in the near future. As we all know, very briefly now, I think my time is running out. I have been handed over slips to asking me to finish as quickly as possible. The other speakers are waiting. Powers of appeal, we all know. Not at your bedside. No, I think it's a larger conspiracy. The Prime Minister is to visit this forum. And that's right. You're being recorded. I know. Right. So, powers of appeal, we can, I can dilate on them. However, very briefly to mention, as of now, the existing statute is, so far as the winding up court is concerned, its orders are appealable to a division bench of the High Court, because the winding up court is a single judge of the High Court under section 483 of the Companies Act. Similarly, orders passed by the SICA are appealable, by BIFER are appealable before the appellate authority, that is the IFER. So far as the Company Law Board is concerned, its orders, both interim and final, are appealable before the High Court. Appeals go before the company bench of the High Court. And interestingly enough, the appeal is limited to a question of law. The statute provides, section 10F provides, that an appeal can be only entertained on a question of law. This is somewhat akin to section 100 of the CPC, which applies to second appeals in a civil proceeding, which says an appeal can be, second appeal can only be filed on a substantial question of law. 10F says an appeal can be filed on a question of law. What is a question of law has, of course, received interpretation in various judgments. Typically, there are three aspects of a matter which can be decided. One is a question of fact, one is a question of law, and the other is a mixed question of law and fact. An appeal provided on a question of law would entail that where, of course, pure questions of law can always be maintained in appeal. The other aspect is where a conclusion on facts, is it appealable or not? There is case law to say that yes, where a conclusion of facts is derived from documents which are not available on record, or which have not been placed by the parties, or on a patently erroneous appreciation of the evidence on record, that finding itself being perverse, being contrary to the record, or being based on no considerations at all, itself is a question of law which can be presented to the appellate court, and that appellate court can go into it. This was settled insofar as 10F is concerned of the Companies Act by the Supreme Court in Dale and Carrington, that is a 2005 judgment which examines this aspect in some detail. Finally, we all know that the amended CPC of 2002 provides and in fact mandates civil courts to explore and to give options to the parties to look at alternate dispute resolution mechanisms. Typically, apart from arbitration, mediation and conciliation. I think many of us sitting here would know that most high courts, including the Delhi High Court, has a full-fledged mediation center attached to it now. And the judges, especially in family matters, matters where people are known to each other, related to each other, those matters come up before the court, typically encourage the parties to go before a mediator who's a trained mediator, a mediator trained by the High Court, to informally advise the parties. A mediation proceeding, as we all know, is a non-binding procedure where there is no recording of events that transpire, there are no pleadings that are filed, there are no statements, no counter-statements. What happens is, before a person who is able to guide the parties sit across the table and discuss their grievances and hopefully find a way, a middle path. There is obviously some give and take in mediation, in settlements, as we all know, to arrive at a conclusion, to cut short the litigation process, to finish the matters once and for all. Under the new Act, Section 442 of the new Act provides for setting up of mediation and conciliation panels for mediation between the parties during the pendency of any proceedings before the government or the tribunal or the appellate tribunal. That is a welcome step, because I know from personal experience that the mediation center of the Delhi High Court has recorded very, very good figures of matters being settled which are referred to it for mediator. It has mediation, it has a panel of mediators, junior mediators, intermediate and senior mediators, and the track record of this mediation processes is very good. It is a welcome step to have this alternate dispute resolution mechanism, which is an informal mechanism. As we often find in India, companies are quasi-partnerships really. Two groups of the family control it, two sets of relative control it, two friends have come together for a venture, they have fallen out. Instead of going through a process of acrimonious litigation, which may last for months, years, decades, it is always good to resort to a forum where you're able to sit across the table, where you're able to try and resolve the matters with the help of a trained person. Well, these are some of the aspects of practice and procedure which I wanted to touch upon. It has been a pleasure addressing all of you today. I hope the discussion that we have had, the pointers that I've explained, the statements I've made are able to help us, all of us, in the new era of practice that we are about to step into, with the National Company Law Tribunal taking over from the BIFER, from the High Court and from the Company Law Board. Thank you very much.
Thank you very much, Mr. Datta, for such a wonderful session on practice, procedure in tribunals, aspects one should know. Now we have with us our learned speaker, Mr. Amit Sibal, Senior Advocate of Supreme Court of India. He has done his education from Sardar Patel Vidyalaya, Harvard Law School, Trinity College, Cambridge University, Balliol College, Oxford University. We welcome you, sir, on this occasion. May I request NPS Chawla, Chairman NAS, to kindly come forward and present a flower bouquet to welcome him on this occasion. Big round of applause for Mr. Amit Sibal. May I now request Mr. Amit Sibal to kindly come and deliver his address.
Mr. Krishnendu Datta, Satvinder Singh Ji, Mr. Vineet Chaudhary, Manish Gupta, Pradeep Devnath, my distinguished colleagues, ladies and gentlemen, friends. It's my great pleasure to be here today, particularly because I think we're all very fortunate to be in this field at the moment. Particularly because we are at a cusp of the inauguration of, as the title reflects, a new era in adjudication of corporate disputes. Both in terms of a new tribunal for which the Honorable Supreme Court has now cleared the decks, as also a new statute enacted by Parliament, some of whose sections have come into play, some sections are yet to be notified. But it is fairly rare in the professional lifetime of a person that you have a convergence of both a new tribunal, appellate tribunal, an entirely new system for deciding those disputes, along with a new act, both of which are obviously attempts to improve on the past, to learn from the past, as Mr. Datta pointed out so eloquently, to fill some of the lacunae that may have existed in the past. And we have in this hall both young and old. Regardless of our age, as far as the new developments are concerned, we are at par. And that is our good fortune, because we can participate regardless of age and experience on an equal footing, as also with those who will adjudicate these disputes, who are equally new to the new statute and to the new system of adjudication. And this forum is one of the forums which allows us to perhaps have a common platform to discuss the prospects that this lays out before us. But the topic that I have been assigned today concerns critical concepts in oppression and mismanagement, in regard to which you all know that the two provisions that are still in force are provisions under the old Act, that is the 1956 Act, 397 and 398. And there are provisions in the new Act that provide for this, that is 241 and 242, which are yet to be notified. So I will in my remarks really focus on the old Act principally, but I will at the end just touch on some of the differences in the provisions in the new Act. But I've set myself to examine today briefly with you, because I know time is short. What are the factors that you will look at? What are the questions that you will ask yourselves and your client when they come to you and ask you, do I have a case to approach the forum for oppression under 397? Or do I have a case to approach the forum for relief against mismanagement under 398? Now, to answer these questions, it helps very briefly if we look at how these sections came into being in the first place. And there again, there's something that Mr. Datta mentioned in his remarks, which struck a chord with me in particular, where he explained how the law has evolved, the view of the courts has evolved, in respect of what you do and what you require in order to hold that there is oppression and relief must be granted against oppression. The old view being that unless the petitioner establishes that there is oppression of one or more shareholders and it is just and equitable to wind up the company, you will not grant relief. But in Needle Industries and later on in Sangram Singh Gaikwad's case, the Supreme Court takes a different view, saying that even if there is no establishment of oppression or just an equitable ground to wind up, we may still grant relief. The question I ask is, why did the Supreme Court change its view? And the answer to that question, in my view, is extremely significant and actually indicates to us what was the original purpose of 397 and 398, the provisions against for prevention of mismanagement and oppression in the first place. When you read cases in the field of 397 and 398, you will repeatedly come across the mention of an old English case of 1843, Foss versus Harbottle. And the rule in Foss versus Harbottle, you read any commentary, Ramaya, etc., you will come across this ad nauseam. But the case is a telling case, because the reported case in 1843 tells us the problem was that the courts were limited in their jurisdiction in England. If there was a case of oppression of shareholders in a company, or there was a case where the company's affairs were being conducted in a manner prejudicial to its interests by the majority in the company, naturally, the majority would not bring an action against its own acts. So what's the remedy? What do? The court in Foss and Harbottle held that generally you will not entertain any action by a minority shareholder. The company should bring the action. But the court left open a small window where it said that where the justice demands, it is too broad a proposition to say that such an action can never be entertained. And over the course of the years, some exceptions were developed to Foss versus Harbottle. But those exceptions were extremely narrow. Without going into the details, the problem remained that the shareholder could ultimately only approach a court for winding up of the company in a situation where there was oppression of the minority or there was misconduct in the affairs of the company to the detriment of the company's affairs. A shareholder could only approach for winding up. What does winding up do? The company may be a going concern, it may even be profitable, it kills the company, it breaks it up, it results in liquidation, selling of assets. And diabolically, what does it do? In many situations where the majority is oppressing, taking unfair advantage, abusing its powers, winding up actually plays into the hands of the majority, because the majority is often in a best position to take those assets for itself after liquidation and winding up, to the detriment of the minority who have may have spent a lifetime building up the company to what it is today. And therefore, perversely, it may actually help the majority if you don't have any remedy in the alternative to winding up, because they will promote that as a solution, and having looted the company already, they will take the remaining assets for themselves, and it's a windfall for them. So, in the English law of companies, they evolved section 210, on which ultimately 397 and 398 came to be modeled, saying that where the company's affairs are being conducted in a manner oppressive to some of the shareholders of the company, and in a manner that it is just and equitable for the company to be wound up, there is a very wide jurisdiction conferred by section 210 on the Company Court in England to grant relief to bring that state of affairs of oppression to an end. And in our law first, in the Indian Companies Act of 1913, section 153C was brought in, which was fairly closely modeled on 210, but then 397 and 398 came under the Companies Act of 1956. And the reason I connected the two issues of the change and evolution of the Supreme Court's view in respect of Sangram Singh Gaikwad and Needle Industries, in respect of whether the court can grant relief regardless of a showing of oppression, connecting with it with the origin of 397, 398, the reason I connect them is this, that really the company evolved as a separate juristic person. Prior to companies, most business was done by entrepreneurs either as proprietorship or partnership. That limited their capacity to do business because there was no concept of limited liability. It limited the size and scale of the business. It was ultimately a fetter on the engine of economic growth and prosperity. A sea change comes when you have a separate juristic person and simultaneously and consequentially a limitation of liability. You have unlimited number of shareholders who are not personally liable for the debts and liabilities of the company. Suddenly, the opportunities for business multiply, expand, they grow. But until Section 210 and 397 come into the picture, that company is in a sense legally an orphan unprotected against abuse. And one of the fundamental reasons behind 397 and 398 is to provide a forum which will, unlike an ordinary court, look after the best interests of that company, that new independent juristic person that has evolved. And the reason for that, of course, is also that in any interaction between a juristic person and biological persons who are the shareholders, there will be highly controversial disputes that will arise. And there must be a specialist tribunal or body that is competent to adjudicate those disputes. At the same time, a guardian of the interests of the company on which those disputes are focused. And this background, I believe, will help to understand what are the critical concepts that are involved in deciding whether or not there is a case for oppression under 397 or a case for mismanagement under 398. Let's start with who can complain in the first place. I don't want to repeat, but it's already been explained by Mr. Datta what the threshold is. 10% of the outstanding share capital or 1/10 of the total number of shareholders can bring an action under 397, 398 to complain. But what can they complain about? What are the words of the statute? The conduct of the company's affairs in a manner that is oppressive of some of the shareholders. Now, manner oppressive, not defined in the statute, deliberately so, rightly so. Interpreted by the courts, old House of Lords case of Scottish Cooperative, harsh, burdensome and wrongful. That is oppression. Again, a phrase that you'll find constantly in the judgments. It gives some guidance, but it will not ultimately tell you the answer. You'll have to look at the facts before you. Is the conduct oppressive? Is it harsh, burdensome and wrongful? What does that really mean? Well, the courts have over the years tried to evolve a system of jurisprudence as to what that really means. What does it mean to oppress a shareholder in the conduct of the affairs of a particular company? It must involve, the courts have said, some element of abuse of power, some element of lack of probity or honesty. They will not put too fine a point on it. Reason? Human mind is ingenious. The human mind evolves new and novel ways to oppress. Any court that defines it in too narrow terms, any statute that dares to define it in too narrow terms will ultimately be constrictive, because it will be a blueprint for a person who wants to abuse power outside the scope of that definition to do so. And therefore they deliberately leave it broad. I won't say vague, because it has been judicially developed, but broad. So one element clearly is abuse of power, an element of lack of probity, honesty. Examples, some short examples. My friend mentioned Dale and Carrington. Classic case of Supreme Court. Person living abroad in Dubai invests all the money to buy a hotel in Kerala. Person, his partner in Kerala, minority shareholder, is supposed to run the business with his money. The gentleman visits India after some years. He finds that unknown to him, behind his back, without notice, he has been overnight, some years back, reduced to a minority shareholder. Kamal Kumar Datta and Ruby General Hospital. I take it no relation. But Kamal Kumar Datta knew his rights. Kamal Kumar Datta came to court alleging, I was an NRI and I partnered with another NRI. And I partnered with my younger brother who was located in India to set up a medical institution. I put in money into that institution. I had shareholding. I had a place on the board. He has cheated me. He has oppressed me. He has ousted me from the board. He has reduced my shareholding. And what is the element that impressed the court in that case? One of the elements, Just to give you a small example of lack of probity. Even small things can show a lack of probity or dishonesty. So, Sajal Datta, located in Delhi, knows very well where his brother lives abroad. Where does he send the notices of meetings? He sends them to local addresses in India by UPC. And he says that I have complied with all provisions of law. I've sent it at the address. He has notice of the meeting. The court says this shows your lack of probity. This shows that every action of yours smacks of lack of probity because you know exactly where your elder brother is, but you choose to send the addresses in India. So clearly you intended him not to attend the meeting and to do things behind his back. Just some small examples. Now, second, it must be in the conduct of the affairs of the company. I recently appeared in a case, somebody brings a petition in the CLB saying, 2 of us are shareholders in this company, I am being oppressed because we entered into a settlement agreement in the United States. We entered into a settlement agreement where I have supposedly agreed to transfer my shares to him. I have agreed to transfer 20% of my shares to him, and this agreement is obtained by coercion and undue influence. I am deeply aggrieved. This is mala fide. This concerns the company. You must protect me because after all, it is transfer of my shares in the company. Classic example of something that is not conduct of the affairs of the company at all. While yes, it may concern shares in the company, but it is not in the conduct of the company's affairs. It concerns a private agreement to which the company, importantly not a party, between 2 shareholders outside the scope of the company's affairs, nothing to do with board meetings, shareholders meetings, etc., and a dispute with them which undoubtedly has to be adjudicated in a suit, in an appropriate forum, but not under 397. Another famous case, and this is an old English case, J.E. Cade, person comes to the court saying, I am a minority shareholder, the company is occupying my farm. Company is occupying my farm, they will not vacate my farm. I am a minority shareholder, they are squatting on my farm, please give me relief against this majority. I can't change their mind because they are exercising their majority rights to illegally occupy my farm. And what's more, they won't even agree to pay me a price, fair value for my farm. Court threw it out, saying this is again not in the conduct of the company's affairs. This concerns immovable property and you will have to file a suit against the company. The company is not being, in this case, used as an instrument to oppress you in your capacity as a shareholder of the company, which brings me to the third concept. The third critical concept in oppression is that the oppression must be of the shareholder in his capacity as a member or a shareholder of the company. So the person who owns the farm is not being oppressed in his capacity as a shareholder. His shares are not being reduced. The majority is not changing anything within the company. But they are attacking his farmland or using his farmland, not in his capacity as a member. He is not being oppressed. Now, there is unique to our ethos and our corporate and social ethos, a vast body of jurisprudence in this country in respect of this requirement that it must be in his capacity as a member. The exception is that there are cases where, for example, you can bring a case for oppression under 397 even in respect of being ousted as a director of a company. Ordinarily not. Ordinarily, terminating your employment, ending your directorship are not subject matter of oppression under 397. But there is a very, very significant exception in this country, particularly because our economy is still young. Most of the business in this country is still conducted by family concerns, closely held companies, companies that have come to be known as in the nature of partnerships, quasi-partnerships as they are called, a phenomenon that was first recognized again in the old English case of Ibrahimi versus Westbourne Galleries, saying very briefly that where a business evolves originally on an understanding that there will be an association based on a personal relationship and mutual confidence. An agreement or understanding that the shareholders will all participate in the conduct and management of the business. And thirdly, where there are restrictions on the transfer of interests outside the company, for example, a preemptive right where you will first offer it to people within the company. Where these kinds of factors obtain, where a pre-existing business has been converted into a corporate entity, you will be willing to examine whether there is an equitable obligation that will restrict the exercise of otherwise legal rights by shareholders and directors in the company. So while a director or a board may have a legal right to take a certain action, while shareholders may have a legal right to not reappoint a particular member of the board, if certain background situations obtain, it's a closely held company in the nature of a quasi-partnership, the company law board or the tribunal in the future will be willing to restrict the exercise of those legal rights based on those equitable considerations. And that is a very vast exception to the general principle that oppression must only be in the capacity of the member as a shareholder of the company. Shanti Prasad versus Kalinga Tubes, another judgment mentioned by my friend Mr. Datta, also says and establishes that it must not be an isolated act. Oppression must be a continuing wrong. Example, a director is liable to retire by rotation. He is not reappointed as a director at the general meeting. He doesn't put himself up for re-election at future general meetings of the company. Can he then say after 3 more general meetings that that particular act of not reappointing me was an act oppressive? And the answer is no, he cannot. It's an isolated act, it's not a continuing act. He did not put himself up for re-election. Another critical concept to understand is an act may be illegal, but not oppressive. And conversely, an act may be perfectly legal, but oppressive. So, it may be perfectly legal, you may give the requisite notices to issue shares, to allot fresh shares. And the notices are duly given, the resolution is duly passed. Let's assume that. But if the purpose of doing all of that is either to maintain or acquire control, if the purpose is to create a new majority or to reduce an existing majority into a minority, then it is prohibited by what the courts have called the proper purpose doctrine. Dale and character. And so there is this other interesting angle that we can't assume that just because something is legal, it is not oppressive, and we can't conversely assume that if it is illegal, then it is oppressive. Just to take an example of that notice of 21 days is required under the Companies Act for a general meeting. Notice is admittedly not given of 21 days. But it turns out admittedly that the person concerned knew about the meeting, let's say by email. He doesn't attend the meeting. Had he attended, he had the wherewithal to change the resolutions in the meeting with his voting power, but he doesn't. He later comes to court saying, look, there is illegality. They have deliberately not complied with the law in sending a notice. The court answers, no, there is no oppression. Because there is nothing harsh, burdensome or wrongful about this. You knew about it. There is no oppression in your capacity. Despite your knowledge, you chose not to attend the meeting. And therefore, we don't even have the jurisdiction to help you here. And then, just and equitable. Not to forget. A prerequisite that it must be, and this is ultimately what is it? It's a filter. The acts of oppression must be so serious, so severe, so grave, that they merit winding up of the company. So it can't be that somebody says 20 years ago, 1% of the shareholding in this company was fraudulently transferred. And I have established that there was a fraudulent transfer, and therefore please hold in my favor. But the question is that act, assuming you've established it, sufficient to wind up a company that is possibly a profitable going concern? It's clearly not just and equitable. Now, there is a debate that has evolved on this. There are certain judgments that take the view, including Delhi High Court, that once you find oppression, then that's really the end of the matter. But according to me, that's a debate about language and semantics. Because all that amounts to saying is that when the court finds oppression, they will build into that the test of oppression that it must be serious enough to merit just and equitable grounds of winding up, but that in fact the company should not be wound up because it would be unfairly prejudicial to any particular member of the company to wind it up, and therefore, instead of winding up, relief will be given as expounded by Mr. Datta under 402, which is extremely wide, and there is really very little limit to 402. There is a significant departure, I may just touch upon, from section 210 of the English Act in 397, which is that oppression need not be of the minority. And you'll find that while the background case law talks repeatedly of fraud on the minority and oppression of the minority, when you read section 397 carefully, you find that there is no suggestion in 397 that the oppression has to be of the minority, and it can just as well be an oppression of the majority. For example, someone wants to convert a minority into a majority at the expense of the majority, and that is very much actionable under 397. Let's move on very quickly to the next limb. So that is covering, there are really two limbs of 397. One is oppression of a member in his capacity as member, and the other limb is where the affairs of the company are conducted in a manner prejudicial to the public interest, which was engrafted by amendment in 1963. You look at the Lok Sabha debates and the finance minister says this is to allow the central government to come in an appropriate case and bring an action or cause an action to be brought under 397 because the affairs of the company are not being conducted in the public interest. And of course that is there. There is not much jurisprudence on the point, but there are various examples of companies that, for example, take loans from public sector institutions and banks. They are being run in a manner that they are unable to repay the loans. Certainly there is a cause of action for the central government to step in, and it has on occasion. Let's move on then to the mismanagement part of it in section 398. Now there, very briefly, if I just read what Adam Smith said in the 18th century on this, and it's telling even today, the directors of such companies, however, being the managers rather of other people's money than their own, it cannot well be expected that they should watch over it with the same anxious vigilance with which the partners in the private co-partnery frequently watch over their own. Negligence and profusion, therefore, must always prevail, more or less, in the management of the affairs of such a company, unquote. Of course, Adam Smith was talking in the context of the notorious companies like the British East India Company that ran on the writ and with the backing of vast imperial powers and engaged in all sorts of abuse. But it was pertinent, really, as a quote also to show why 398 came into being in the first place, to address the issue of mismanagement, where a member, again, who satisfies the threshold of 10% or 1/10 of the shareholders complains that the affairs of the company are being conducted in a manner prejudicial to the public interest or in the manner prejudicial to the interests of the company. And you'll note already there is some overlap between 397 and 398, because prejudicial to the public interest came into 397 and prejudicial to the public interest is also part of 398. 398 also has another limb that is a manner prejudicial to the interests of the company, and there is a further limb that is where a material change which is not brought about by or in the interests of creditors, including debenture holders or any class of shareholders of the company, has taken place in the management or control of the company, whether by alteration in its board of directors or in its managing agent or secretaries and treasurers or manager, or in the constitution or control of the firm or body corporate acting as its managing agent, or secretaries and treasurers, or in the ownership of the company's shares, or if it has no share capital in its membership, or in any other manner whatsoever, and that by reason of such change, it is likely, and I'm emphasizing that because it is prospective, it is likely that the affairs of the company will be conducted in a manner prejudicial to public interest or in a manner prejudicial to the interests of the company. Now, if the company law board or tribunal is satisfied that this is the case, then again they can take whatever action is necessary to bring that state of affairs of mismanagement to an end. But reading the section, what are the salient points that jump out at us? Number one, as drafted in the 56 Act, the scope of 398, first of all, is wider than 397. Why? There's a prerequisite in 397 that on the facts, it is just and equitable that the company be wound up before you can grant relief for oppression. But in 398, there is no such prerequisite that it is just and equitable that the company be wound up in order to grant relief under 398. That's one point to note. Second, that the 398 will not allow and doesn't stand for interference with simple commercial judgment or business judgment decisions. The court is not there to second guess commercial judgment. Let's assume that a company is being run in accordance with the provisions of the articles and the memo. It's being run generally in an honest manner, but certain decisions have caused losses to the company. Is that enough for 398? The answer is no. That is not enough. A way to fashion it might be akin to the test of Wensbury unreasonableness in administrative law. Principle being evolved that the courts in administrative law will not interfere with the actions of a state actor unless, or a state authority, unless the action is so unreasonable that no reasonable authority acting in its right mind could have come to such a decision. Now transpose that principle to company law and examine the commercial decisions of a company. One way to examine and one approach that has been commended in the case law is the action of commercial decision so unreasonable that no reasonable board could have taken such a decision? Now, if you find that the answer is yes, then it's certainly a fit case under 398. But by and large, the guideline is that we will not interfere with mere business judgment or exercise of corporate democracy. The other point to note, and this has some connection with the lessons we learnt on draftsmanship, is that when we draft a petition for mismanagement, we must be sure that we have the material particulars of the mismanagement. It cannot be in the form of a fishing and roving inquiry. And that is also a point of substance, where a person comes to you and says that, look, there is, I believe, mismanagement, but I know not what it is. Let's ask the company law board to open the box and find out whether there is mismanagement. Let them find it out for us. But frankly, I can't show you today that there's a prima facie case of mismanagement. The answer is no. There must be a prima facie case at least of mismanagement, which can then merit a prayer to investigate the affairs of the company and unearth that mismanagement. But Mota Brothers and various other cases will tell us that it can't be a fishing and roving inquiry and using the tribunal or the company law board as a tool to engage in such a fishing and roving inquiry. 402 has already been covered in extenso. So let me come straight then, having covered 397 and 398, the critical concepts to bear in mind, to 241 and 242, very briefly to say this, that what are the salient differences which will no doubt come up and be addressed before the new tribunal when it comes into being. Or if the provisions are notified before that, then before the company law board. It's very interesting that we have come with 241 full circle. Why I say that is that 210, the inspiring provision in the English Act, really combined aspects of oppression and mismanagement in one omnibus provision. And we then moved away from that in 397 and 398 by separating the aspect of oppression from the aspect of mismanagement. But what we no doubt found with the evolution of case law, pursuant to 397 and 398, and you'll find this when you read the judgments, is that the two aspects of oppression and mismanagement are inextricably interlinked. You will rarely find, but rarely, a discussion that separates the two. And the reason for that is also not hard to find, which is that ultimately the concern is the running of the company and the interests of the company. And oppression and mismanagement concern the heart of the company. And so the discussions will be contiguous with each other. Perhaps in recognition and in reflection of that, in the new Act, they have once again come full circle to combine the two, as perhaps we did in 153C, now so in 241. And you find 241, the first part, combines the limbs of 397 and 398 together. And the second part really takes half of 398, and it's all in one omnibus provision, 241. That's one point to make. The other aspect which is interesting is that today, if you look at 241 literally, but this will no doubt be an issue that will be discussed much more than I am discussing today, is that it appears as if now, even when you come with an action for mismanagement, a prerequisite for relief is that it be just and equitable, that the company be wound up. Because under 242, the relief under the new Act, if there is a ground for just and equitable winding up on the facts of the case. Now, no doubt that will be debated as to whether that applies to mismanagement, because if it does, then it does to some extent narrow the jurisdiction to grant relief for mismanagement alone. Because you will have to show that the mismanagement is such that it crosses the threshold and is so bad that it makes it just and equitable to wind up the company. The wording also in the draftsmanship is a little, how shall I put it, perhaps not the best wording, because it says just and equitable to wind up the company, but it should not be done because it is unfairly prejudicial to such member or members. Now, such member or members, no doubt ingenious counsel will argue, relates to the member complaining of oppression, not mismanagement. And so this is no doubt something that will be debated, and that debate is triggered by the wording of the new statute. The other point to make is that in 242 now, what they have done, and this is why I started by saying that we are fortunate that the new Act engrafts lessons and improvements from our experience with the old, is that you can find that the various limbs under 402, which went up to about G, are now expanded beyond G in 242 to add various new limbs of relief. Of course, without prejudice to the generality of the relief powers, to add, for example, the power to remove the MD, the power to remove directors, the power to appoint people in their place, the power to do various other things, and these have all been the subject matter of reported judgments of the Company Law Board, the High Court and the Supreme Court over the years. And drawing from that experience and those lessons, they have now put it into the statute itself, so that counsel has to spend less labor making the point in court, which is obviously a salutary development. Another aspect I find gratifying in the new statute is that in the reliefs, they have pointedly put something that was absent earlier, but there was a crying need for it in my view, which is costs. Today, the tribunal, once the Act is notified, has the power, the jurisdiction to impose costs, thereby having the ability to deter frivolous litigation that comes to court without a real cause of action, that does not take into account the fact that while the jurisdiction under 397, 398 and 241 and 242 is extremely wide, it does not mean that it is unlimited. And when someone is either deliberately or inadvertently blind to its limits, and wastes the time of the court, there is an opportunity, or abuses the process of the court, there is an opportunity to impose costs in an appropriate situation. In fact, it is an experience of all of us practitioners that we sit in courtrooms that are adjoining in the company law board, and we can hear the high decibels in the adjoining courtroom, and we wonder whether it is the lung power of the counsel in the other courtroom or the walls are too thin. But my experience tells me the higher the decibels, the weaker the case. And that's why I find it gratifying that they have put these costs in to deter frivolous litigation. And that's why a forum like this helps us evaluate and determine, delineate, guide as to what are the pitfalls, what are the guidelines, what are the factors we can look at to advise our clients in the right way, perhaps to avoid a case of frivolous litigation where both we and our clients lose out because it is found that our case cannot stand on its own legs. Let me close just with this thought, that ultimately, where do we stand with 397, 398, which possibly accounts for the largest single body of jurisprudence on company law in this country? Where we stand ultimately is that if in advising our clients and analyzing disputes that arise in a corporate structure, we keep at the back of our minds that what the court, the tribunal, will have at the forefront of its mind is the interests of the company. We can't go far wrong. Let that be the lodestone, the compass, the weather vane of our advice. If there's nothing else you take from this little talk, you just take home with you that concept, that it is uniquely the jurisdiction, the lookout, the power and responsibility of the Company Law Board and the National Company Law Tribunal, as it will come into being, to look after the well-being of the company. You will equip yourselves in the best possible manner to face the challenges of oppression and mismanagement as they relate to any company. I'm very grateful for the opportunity to share my thoughts with you, and thank you very much.
Thank you very much, Mr. Sibal, for your address on the critical concept concerning operation and mismanagement. I have seen that almost 90% of the cases in the CLB are relating to operation and mismanagement. I am right, sir? Almost 90% of the cases, maybe more than that, are based on the operation and mismanagement. Thank you for guiding on the operation and mismanagement. I hope you are leaving. Vineet has told me that you are leaving. Thank you very much, sir, for sparing your valuable time and sharing your rich knowledge and exposure with the participant. Big round of applause for Mr. Kapil Sibal. If anybody is having questions relating to operation mismanagement, he or she can ask maybe one or two questions to Mr. Amit Sibal. Any questions? As he is leaving. All clear, sir? No issues. May I request Mr. Vineet Chaudhary and Rajiv Bajaj to kindly come forward and present a small moment of our respect to Mr. Kapil Sibal.
I dare say that the lack of questions doesn't reflect the fact that we've detained you so long into the lunch hour, and I apologize for that.
Big round of applause for Mr. Kapil Sibal. Mr. Amit Sibal, sorry.
Big honor for me. I'm grateful to the Council and the Institute of Company Secretaries of India.
It's a green certificate. We will be planting a sapling on your name in the days to come.
Thank you so much.
It's a green...
And thank you for accommodating me. Actually, I have an ongoing hearing in the High Court. That's why I requested this accommodation. It's on after lunch. Great.
Thank you very much, sir. Thanks a lot. Our next speaker is Mr. Satwinder Singh, who is our Central Council member and partner Vass Associates. He will be dealing with the topic convergence of SICA, a paradigm shift in industrial sickness and rehabilitation. He needs no further introduction. May I request Mr. Satwinder Singh to kindly come and start with his presentation.
A very good afternoon to all of you. I know because it's going to be a lunch time, and NPS Chawla asked me, sir, since Mr. Amit Sibal is still on his legs in the High Court, would you like to take it up? I said, no, NPS, because my purpose of bringing these two luminaries was something different, because as and when NPS's team goes to them, he always comes, sir, आज मजा आ गया अमित सिब्बल से के साथ काम करके या दत्ता जी के साथ बहुत कुछ सीखने को मिलता है. And I said, यार, you are so fortunate, you always learn at the cost of the client. And that made me, because this NCLT, when it is coming, because I know that, okay, when I'll go to their chamber, the next day a huge bill will come to us for the conference or for the appearance. And I said that, okay, this is an opportunity. We'll personally request Mr. Sibal, Mr. Datta. And I think sitting here, you will vouch that the kind of people they are, and it is always a learning experience. And I said that, okay, even if I will be left with no time, or even a 15 minutes time, I will be more comfortable, because in any case, somebody else was to speak on this topic. And last Monday, he said that I'll not be coming. NPS was trying hard to bring one or two more persons, he was saying, but at the end he came to my chamber. Sir, मैंने आपका नाम डाल दिया, अब आप ही देख लेना. I said, okay, I'll have to see. So, I will just try to conclude, because in any case, we will try to wrap it up by 2. And I don't want that, okay, those mouse inside the stomach is bothering you. So let's bear it up for 2 o'clock, and I'll try to wrap it up by 2. In the morning session, I think Justice Sikri very precisely concise that why the law and economics has to go in tandem, and he said that, okay, if given a chance, he will try to write another judgment on that, because the economics has also to prevail. And this is how the concept of merging SICA into the Companies Act, I think the practice and the procedure of the SICA, if you will take it up, and I will take you why I'm saying that what is the broad framework of SICA, which is still in existence. And based on that, how we can think about that what is going to come is an important aspect. So I'll skip the preface, but only to that part that till the time the provisions of NCLT is to be operative, the SICA will continue. Let's see the broad framework of SICA as on date. What is this broad framework? That industrial company having sick or potentially sick undertaking, if that is there, then the SICA will be applicable. And then in the SICA they defined what do you mean by industrial company and what do you mean by industrial undertaking. So those sections are there. If you take it up for this thing, that's industrial undertaking, they have given industrial company as section 3E, which has the meaning under the Industrial Development Regulation Act. And similarly, the ancillary companies or a small scale companies are not there. I still remember in the early 90s, we all heard about AB Corp, Amitabh Bachchan Corporation Limited. Many of youngsters might not be knowing, because I know that at one point of time, if Mr. Datta vouched for it, it was into a mess. Huge financial mess. And there was the issue that how to take the shield of section 22 of SICA, that all the proceeding can be stayed. And one good thing happened with the legal luminaries, They said, why not you amend the memorandum? Why not you start manufacturing the cassettes and then you bring that AB Corp within the meaning of industrial company, and then we will approach under SICA to BIFAR. The moment that petition is admitted, we will be stayed from all the other proceedings for this thing. This was a classic case which had happened at one point of time. So that was the industrial undertaking, and that is still there. Now, I will try to bring you, because that's the important, that what do you mean by sickness? That which is there. An industrial company being a company registered for not less than 5 years. That's the one part. A company being a company registered for not less than 5 years. So below 5 years, the application under SICA cannot be maintained. That was the one part. So in the 5th year, when at the end of the financial year, accumulated losses equal to or exceeding its net worth. So you have on the one side is the accumulated losses, on the other side is your net worth. And on determination of sickness, you have to report within 60 days. And why I am highlighting is, look at the penal consequences. I have seen many companies, they are not even reporting potential sickness, and I'll draw your attention to the penal provision. And I was astonished because I was to be appointed as a director in one of the companies for this, and though I've been appointed for this, and I said that even on the potential sickness, I can't be a director till the time you set right the things, I'll take you for that. Potentially sickness company, which is still applicable as on date. An industrial company whose accumulated losses as at the end of any financial year have resulted in erosion of 50% or more of its peak net worth during the immediately preceding 4 financial years. So in the 5th year, so long 5 years are not completed, so you can still take a shelter, SICA is not applicable. But in the 5th year, if peak net worth and your accumulated losses to the peak net worth is more than 50%, then you still come within the purview. And you will see many companies having losses more than 50% of the net worth, and this is the penal consequences. What is the penal consequences? Every director, if you have not reported, of the company who is in default shall be punishable with imprisonment, which shall not be less than 6 months, but which may extend to 2 years, and with fine. So it's not a compoundable offense. Minimum 6 months if you have not reported even the potential sickness, and you are an industrial company falling within the realm of SICA, you are subject to those penal consequences. Now let's look at this. Look at this case study, I'm putting it to you. There is a company ABC Private Limited, which is a wholly owned subsidiary of a foreign body corporate, incorporated in the year 2010 under the provisions of the Companies Act 1956. It is an industrial company. There are no secured creditors. Everything is being funded by the parent company. And the provisional financial position as on 31st March 2015 is as given in this. Look at this. Tell me, when there is in the 2010, the net worth is 22, accumulated losses are 14, net worth second year 50, and largely it is being funded as a share capital, accumulated losses 35, third year, fourth year, net worth is 100, accumulated losses 50 to 80, 14, 15 again funded, net worth is 135, and the approximate losses as on 31st March 2015 will be 110. Tell me why I'm just making it is, I'll try to draw the distinction. What is being changed now? First, tell me what this company will be. Will it be a sick company or a potentially sick company? Pardon? Potentially sick company. Yes. When you have to see the potential sickness, when you have to see the sickness, it is on that financial year. When you have to see the potential sickness, it is the preceding 4 financial years, the peak net worth of preceding 4 financial years. And it is 50% or more, even it is more than 100%. But still it is a potential sick, because when I have to see the sickness as on the financial year, then it is coming 135 and 110. That's one part of it. Now, this is a case which I was handling. And when I told them that, okay, all the directors will be liable for this prosecution, and they don't want it to report, they said, why? Why we should be treated as a sickness when we were funding? And they said, and I told them that, okay, the law is being changed. Now the concept of net worth is being shifted to a liquidity criteria. And they understood it. They said, how to get over from this? Believe me, which I am taking you, though I charged for that assignment, which they paid me a good amount of money. What would be the best solution, which I will say that, okay, let's get over from the potential sickness, which we discussed in the month of February. And last week I got the order. What would have been the best way? No, I can't increase the capital because they said we don't want to pump in the money. What could have been the best way? We thought about it. Any idea? Pardon? Now, how will, if you alter the object clause that, okay, the company is an industrial company. No, but why? I can't stop my business. That's what I'm saying. I can't stop my business. So that is where I will say a demerger, then I will create two, then what will happen for this? I simply said that let's continue with this. I said that, okay, let's go for a reduction of share capital, set of the losses. Because I know that the law is being changed. I made the reduction of share capital done. Because what it says that your accumulated losses are not more than 50%. If I set off those losses with the share capital which is already there, I'll still have the share capital. My losses have been to the extent of up to 31st March 2014, against 135, I reduced the losses. Then that issue came because the carry forward of losses, this is a big tax benefit. I checked it out with my team and I was sure about it, that even if you set off your losses against the capital, your carry forward under the income tax losses, you can still continue to make it, except that in future if profits comes, there can be a MAT application and other things. And when I gave that idea, they said it's a wonderful idea. Let's go for reduction of share capital. Within 3.5 months, we completed the entire exercise. And I made the company out of the potentially sick company. Now, what is the law which is evolving now? As I told you for this. In the new Companies Act, there is no concept of potentially sick company. The concept of net worth, that has gone. The concept of liquidity has come in. I'll explain you. I've tried to make a distinction between what is in the Companies Act 2013 and what is in SICA. And when you look at it, you will find for this. There is no concept that the company has to be an industrial company. No. It may be even a trading company, no problem. So far, you are maintaining that liquidity criteria. And that liquidity criteria is that if the demand has happened, here, the moment your net worth is eroded, you are compulsorily required to go into BFR. That is not a case unless and until the application will be filed. I will bring all those issues which will be there. And then the companies like what it has been done by AB Corp to make it as an industrial company, take the benefit of Section 22, that automatic benefit will go away. Henceforth, once the provisions will be applicable, the shelter of Section 22 will not be available for this thing. So I'll quickly run because it's hardly 7 minutes left. So first is that now it is NCLT and the appellate tribunal instead of BIFR or AFR. The sickness of 50% criteria, as we discussed, there is no such criteria. Now, what is in the Companies Act is that if the demand is made by the secured creditors and you have not been fulfilled the demand of more than 50% secured creditors, then within 30 days, the secured creditors can make an application, or the company can make an application to the tribunal to declare the company as a sick company. It is on your application or on the application of secured creditors. It is not automatic that, okay, your net worth has been eroded. Now, in my case, there are no secured creditors. Irrespective, even if I have a default to the unsecured creditors, I can't be termed as a sick company because there is no provision that even if there is a default to the unsecured creditors, I can be termed. They can have a different, application. They can go for a winding up that it is, I'm unable to pay debt and other things. But for determining the sickness or coming to that sickness, there is no applicability so far, even if I have a default to the unsecured creditors. The term sick company is not defined in the new act, as I said, as against SICA which was there, that it is the tribunal who has to declare, otherwise it was on its own. Potentially sick company, I think it's gone, as I mentioned it to you. Stay on pending proceedings. It is only when you will make the application to the tribunal under Section 253 that please stay any proceeding as specified, not as automatic as earlier it was in SICA, and the stay would be operative only for 120 days. Non-disposable obligation, again on filing the application, the company shall not dispose of any assets, otherwise enter into any obligation, except if done, it is in SICA it was BFR may by order in writing direct the sick company not to dispose it of for this. Limitation period. Stay order period, if there is any stay order and other things, that will be excluded while calculating the limitation period, but in SICA there was no such provision. Now, application by a secured creditor to the tribunal for revival and rehabilitation. If your application is admitted under Section 253 and the tribunal has determined, yes, there is an event of sickness, you have not paid to more than 50%, and this is an event, let's explore the possibility of revival and rehabilitation. So, the tribunal will start, and within a period of 60 days for determination that has to be adopted. But there will be the overriding provisions of SURFACI Act as is given in Section 15 of SICA. But here, I think the similar SURFACI Act has an overriding effect for the abatement of any reference made or to be made. Secured creditor representing 75% of the outstanding debt have taken measure to recover this. If that is happening, so SURFACI will override SICA or the new provisions under the Companies Act. And then if it is determined, then the tribunal will has a reason to appoint the interim administrator within 7 days from the receipt, but in SICA, like, it's the operating agency to be appointed, which will determine the revival and rehabilitation scheme. And this is where the duties and powers, where the company secretaries can be appointed as interim administrator. This is a big, big opportunity, both as a company administrator and the interim administrator, from the data which has to be taken. And once the interim administrator has been appointed, the role is to convene the meetings of the committee of creditors, which the interim administrator will constitute, to provide report to the tribunal within 60 days, to take over the management if the tribunal asks. That's a wide power which has been given, that, okay, you remove those interim management, you take it over, take all those decisions. But there was no such power with the BFR to direct the operating agency to take over the management, on the ground that there is no scheme of revival. Interim administrator will appoint the committee of creditors before calling the meeting, with maximum 7 members constituting a representative each of every class of creditors. Company administrator, on the date of hearing fixed by the tribunal and after considering the report of interim administrator, tribunal, if think fit, feasible to revive and rehabilitate it, it shall appoint a company administrator. Then the company administrator will prepare a scheme which will be considered by the creditors, but there is no such provision in SICA. However, the operating agency appointed is responsible to prepare the scheme. Appointment of administrators, how the administrators have to be appointed. It is by the tribunal shall be appointed from a data bank to be maintained by the central government or any institute or agency authorized. And this is the point which we are driving, that, okay, which I had made a point to the president also, that, okay, why not we should make the Institute of Company Secretaries as one of the data bank agency, so that our members can be appointed as the administrators and interim administrators. No such provision. BFR normally appoints an institution as the operating agency, where here the company secretary, chartered accountant, and the cost accountants can be made it. Takeover of the SIC company may form part of the scheme, where the takeover is not earlier, it is a revival and rehabilitation, not the takeover under the BFR, there was no provision to that extent. Scheme to be binding, and this is, once approved, the scheme shall be binding effect from the date it becomes operative. Monitoring of the scheme, the company administrator appointed by the tribunal shall, on order by the tribunal, monitor the implementation of the scheme. Here the operating agency appointed by BFR is responsible for monitoring the scheme. Then is the winding up of the company if the scheme is not approved by the creditor. If the scheme is not approved by the requisite majority of the creditors, the company administrator shall file its report with the tribunal, and then the tribunal shall conduct the proceedings of the winding up. As Justice Sikri also said, that, okay, there is a issue that, okay, let it be a single window for all taking it up. Earlier it was the BFR, then the matter goes to the High Court. High Court has to take it up, and the matter was prolonged. Here the tribunal itself can order the winding up for the company. Then is again the winding up the company if the approved scheme fails to implement. That is also the event where in SICA there no creditor approval was required. The operating agency, in case where the scheme is not implementable, may seek for the change in management of the company, and if the change of management does not take place, then the winding up is recommended to the High Court. So there was a concept of rehabilitation fund. Here it is a rehabilitation and insolvency funds. And then the punishment and penalty, those have been provided. No, in the Companies Act, no, whoever violates the provisions of Chapter 19 or makes a false statement, then, or attempt to tamper, he shall be punishable with imprisonment up to 7 years and fine which may extend to rupees 10 lakhs, where earlier it was punishment was imprisonment up to 3 years and which may be coupled with fine. No such provision for cognizance, but here in Sika they said no cognizance by any court of any offence mentioned above except on complaint by such persons. That is where I am just looking at this. Let's see this, some of the challenges. What are those challenges? As I said to you, the concept of sickness has gone. So instead of the net worth criteria, there is an automatic sickness. The concept is, so far you have a liquidity, your promoters can provide liquidity, and you are satisfying the criteria that at least to more than 50% of your secured creditors, you are paying them, you are not sick company. Now what happened to that part? Once this transition will happen, unlike in other matters where they say all the matters pending before the High Court in respect of mergers, amalgamation, or the matters in the CLB, these will be transferred to NCLT, and the NCLT will start from where it is there. But I think till the time for all those arguments, the matter will be, heard fresh by the judge as normally happens. Unless and until, I will say, it was partly heard in the High Court, the matter goes along with the judge. But when the matter will be shifted, I think that will not be a case. Probably you will start it afresh. But here, if you have any pending proceedings before BFR, even the proceedings have been completed, but the order has not come, and the NCLT becomes operative, you are out of that. All the proceedings pending, that stands abated. And now you have to see whether you are falling within the fresh criteria or not. And if you are falling within the fresh criteria, then you file a fresh application before NCLT. There is no transfer mechanism. As regard the transfer of proceedings are there from BFR or AFR to NCLT or AICT for this thing. Overriding powers, as I mentioned it to you, missing in the new act, but how to protect the unsecured creditors, that's the one part. I think the law has made it clear as regard the preferential payments are concerned, that the unsecured creditors have the first right. So long you are satisfying the secured creditors to more than 50%, they says, let's see that there is a revival and rehabilitation. I'll not fall within the category of sick company. There is no revival and rehabilitation even for those companies. That is only when I'm faltering even to the 50% of the secured creditors, then I will go to the court, or the secured creditors will go to the court, then they will see. So envisaging that, okay, in future we will have a problem, they will not problem when the promoters are saying that, okay, we are funding the company like this. So that can be a one issue. Or how to this thing is, then I was just reading section 442 of the Companies Act, which mandates that best effort should be maintained, that within 3 months from the date of filing, whether it is a winding of filing, whether it is under, revival and rehabilitation, or any application is made, within 3 months, the board should make all-out efforts to dispose of this application. If it is not being happened, then they have to record the reasons. The chairman has to record the reason that why this disposal. In the morning when I was coming, I asked Justice Kumar, sir, this 442, I am not sure, because that even extension is only for a period of 90 days. That's a timeline which has been given. So your matter should at the most has to be disposed of within a period of 6 months. So I asked this question, sir, is it practical? Is it mandatory clause, or it will be only a directory clause that, okay, then there will be reason of, natural justice and other things. And then he says, Satwinder, you know very well. And there are matters where yesterday even when I could have disposed of the 2 matters, both the parties were saying the senior is standing on his legs in the Supreme Court and other one is standing in the High Court. So both the matters were adjourned. He said, I know that if I will investigate these So probably the judge, I could understand that the senior may not be in the before this thing, but this is what is happening. That's in the morning I had a discussion when I was asking about this thing. So qualification criteria for administration, where having special knowledge or experience, that is there at least 10 years, total receipts of 15 lakhs. So this is what is in the draft rules which has come. And probably the one in the draft rule, they said that the company secretaries who can appear before and the chartered accountants who have 5 years of experience, and I've raised this issue, is that since there is no bar as far as the advocates have to appear before the NCLT, even if they are freshly graduate, why you are putting restriction on the company secretaries or the chartered accountants? Even the fresh past company secretaries, so far they have a caliber and other things. Why you are putting in the draft regulation that they must have a minimum criteria of 5 years? It will restrict their applicability. That issue, in any case, we will take it up at an appropriate forum. So, as role of company secretaries, I will say that larger role now coming, apart from that you will be coming or appearing before the court, that's a big opportunities. You can also act as an interim administrator, you can act as a company administrator, you can act as an advisor to the board. There's a larger, I would say, a role one can play. It is up to us, and that is what I think has been conceived time and again at the institute level, at the NIRC level. Maybe NP as the chairman is working hard only as a continuation process for this thing. There is also, I think, tomorrow there's a moot court being organized for the members, just to equip ourselves, because the presentation skills, the morning Mr. Justice Kumar was saying that there are many lawyers, and I don't want to name it right now, very senior lawyers. They said they took a course of communication skills and the presentation skills from the Institute of Communication and Drama Management for this thing. And I would not like to name, because the person he named, he said even he did, and he's one of a leading luminary for this thing, is because when you go to the Supreme Court, I think it is a matter which Mr. Datta presented. It is, what is the core issue? Within 2-3 minutes, if you are not able to present your matter, either your file will go here side or this side. This is certain things, certain, I would say, the court crafts, which we all have to learn. And I probably was seeing that, okay, I would be a listener today, and I should listen, and that's why I made it that I should have the privilege when I should hear Mr. Datta. I know that, okay, as and when he is appearing before CLB or in any court, and I happen to be free, I sit and see that, okay, how he argues, if I can imbibe certain things, either from Mr. Datta or Mr. Sablok or some seniors thing. So these are the things we all have to imbibe for this. With this, ladies and gentlemen, thank you very much for your patient hearing.
Thank you very much, sir. Due to paucity of time, we are not taking any questions, as we have to vacate this particular hall for security reasons. Lunch has been arranged in the another hall, Desire. Kindly be seated for 2 minutes. Before concluding this wonderful program on NCLT, a new era for corporate adjudication, I would like to make 2 announcements. One already shared by Mr. Satwinder Singh ji. Another, at 4:30 p.m. we will be having our 34th AGM of members. Would request you to kindly be present at the AGM. That will be held at the Desire Hall of Lee Meridian only. And on 31st of July, we will be having Mega Student Program Conference at Air Force Auditorium. Would request each one of you to kindly allow and motivate your trainees to participate in this mega conference. And that will be on soft skill, I suppose. And some motivational speakers will be there to motivate our trainees to take their careers ahead. Thank you very much. Now I request my Treasurer, NIRC, Council colleague to kindly come forward and propose a hearty vote of thanks.
Mr. Dattu, Senior Advocate, Central Council Member Satwinder Singh ji, Vineet Chaudhary ji, Vice Chairman Manish Gupta ji, Chairman NIRC NPS Chawla, Manish Agarwal, Rajiv Bajaj ji, Center Council member, senior member and my dear friend, good afternoon to all of you. Since we all are in hurry to rush for dinner, so I would not take, for lunch, sorry. So I will not take much time. I hope our speaker justice today with their respective topic by enriching us all about with their respective topics. And I am sure after this session we will understand how to deal with the case at NCLT. Friends, before NCLT being operational, it's really an opportunity to us to present there and to understand all about the practical aspects of this NCLT. I extend my heartiest thanks to Mr. Dattu for sparing his valuable time with us. I extend my special thanks to Satwinder sir, who always guided us, support us in all possible manner. I request Mr. Rajiv Bajaj to please come forward and present green certificate as a token of respect to our speaker, Mr. Datta. I request Manish Agarwal ji, Council Center Regional Council member, to come forward and present green certificate to Satwinder sir. Thank you, friends. Now please, this time I will not miss. Please join us for lunch.
Thank you, Pradeep. Just a moment, please. As he said, for dinner, we will be organizing a dinner for families and members on 31st itself at Air Force Auditorium. There will be a motivational talk for members and their families. That will be followed by dinner on 31st of July.
I'll briefly share. Thank you.